Grand Rising, everybody. Today is Saturday, August the 22nd. We are here in another Operation Wisedome with my boy Michael Carey. Oh my gosh, my
Yes,
boy Michael Carey.
sir.
You know what's kind of crazy is when I first met Michael, I was like, man, this dude is such a jock, bro. You know what I'm saying? I was like, bro, I was like, but when it comes across time, like you come to see the intelligence of people, and you cannot judge a book by its cover.
Yeah,
It's pretty amazing because Michael has really never had to deal with anything that was like law or anything like that. And he first came to me, kind of, I think, somewhat in the middle of his situation, as
yeah.
far as court is concerned. And after, he came to me, we just worked together, and to see how Homeboy has taken off is literally outstanding. Like it's blown my mind. It's phenomenal in relation to first off just what he's done, and his eagerness to learn on his own and say, you know what, I'm not going to depend on nobody. I'm just going to go out here and get it and figure out how to do it. I've taken a little bit of what Cam has given me, and now I'm going, and I'm not stopping. And that's been something that's been really amazing to me because he is far from a jock. He is definitely a genius, and
Hey,
so proud of him and everything that he has accomplished thus far. Even though he has to deal with with everything that he's dealing with, he has not stopped. He has not faltered, and he is not failing in any form or fashion because of the conviction that he has within. So I want everybody to unmute, and y'all welcome Michael to today's Operation Wisdom.
Michael, welcome,
Yeah,
brother.
welcome, Michael.
Welcome.
Welcome.
Grand
welcome.
Rising, Michael.
Thank you, everybody. Thanks for being a part of this.
Yeah. So
Welcome to your
Michael,
new family, baby.
oh, sorry, Chris. Say that again. I think I blocked you out.
Welcome to your new family, man.
Oh
Yeah,
well,
we're
Michael's been a
diligent
Opinion.
here.
Wisedomian for a while though. Don't get
Yeah,
it
Oh,
twisted. Yeah. He's been a Wisedomian for a grip. I think
I don't
maybe at
make
least
it
six
to the
months.
Saturday events often, because I'm. By the way, I'm doing all this while being a single father. So shout out to the dads who step up. Cam, as one of
Shout
them,
out, bro.
step
Shout
up
out.
and handle their business as men, men of God, and fathers that are well needed in this world.
yeah.
So I've got a lot of responsibilities as well. Aside from handling my own legal issues and work, I still got to work, still got to provide all these things. So I don't make it Saturdays often, but I'm here.
Yeah, my boy is here. Okay, so how you want to do this, bad boy? Because I think it's kind of cool. What do we? First off, just let's introduce you. Who is Michael? Who is Michael?
Yeah. So I am somebody that's just like most of you. Uh, I never really had legal training or legal experience. I don't consider myself an incompetent person by any means, though. Um, my experience came from feeling like the system was failing me and a desire to kind of learn and understand and know for myself what's going on because I think it's important. And when I was working with another gentleman, Tony Friere, shout out to Tony, Lawful Patriot 5. If anyone wants to look him up on TikTok, he might have changed his TikTok thing. But when I started working with him, he told me a couple maxims and stuff that really stuck with me. And one of them was that ignorance of the law is not a defense, and that applies to you as well as the court, but it definitely applies to you. And another maxim that really kind of stuck with me was, "He who could be deceived shall be deceived." The law does not, it's not illegal. Like, for example, it's not illegal for a cop to lie to you during detainment. So, with certain things like that, once I started learning those little things, I was like, I see. Then you start learning other stuff about the legal system works, and it makes you really want to not be that guy who can be deceived, right?
Right.
So, when I felt like the legal system had failed me and I was unlawfully arrested, I decided to really delve deep and kind of handle things. And the biggest turn of event for me was I was lied to by a public defender right to my face about multiple things. And it became really shady when I wanted to go over evidence with him. And he always seemed to not have time.
Now, is
So
this in the very beginning of everything, or is this later on throughout your
So
deal?
this was pretty much in the very beginning.
Yeah.
This was in the very beginning. So for those of you that don't know my story, I'll give you a very brief rundown. I actually had two DUIs, and they were within about 5 months of each other. Now the first DUI, I was not driving. I never drove intoxicated whatsoever. I went out, had some drinks with a buddy. He had too many. I got him to my car because I was driving that night. I carried him to my car, and then I got in the car and I realized, you know what? I'm too drunk to drive, so we got to post up. And so we posted up, and I ended up falling asleep, and the officer pulled me out and arrested me right then and there. And so that DUI, me and the public defender ended up beating at trial. They reduced the charge from DUI to public intoxication, tried to pursue a public intoxication charge, and then we beat that case at trial because there's three elements of public intoxication. One is that somebody's in the public space, they had me there. Two, somebody is willfully intoxicated. Willfully is the tricky word, but if you want to give it to them, you'll say that they had me there. And then the third element is that someone is so intoxicated they are unable to provide for the safety of themselves or others. Now they didn't have me there, and my buddy came and testified on my behalf and testified that I got him from the bar to the car safely, and that we kind of posted up in the car in a safe place, out of public sight, and these things. And then the jury ended up finding me not guilty, which was really cool. But while I was facing that charge, I got a second DUI, and that night I was the designated driver. And
That's the night. That's the night that we're gonna be speaking on today, huh?
yes,
Okay.
and this is I'll give you a timetable, right? So the first arrest happened in September of 2024, or was it 2023? It might have been.
Well, it
No, it
might
was
have been
24.
2020.
It was
Okay.
no, it was 24. Yeah. No, it was 23.
Yeah, I was gonna
Shit.
say. Yeah, this
Yeah.
was February.
Yeah. So it was September 23. This arrest happened February 24, and I still hadn't even gotten to trial for the first one. Trial for the first one happened in July of 24.
Hmm.
So to give you guys a little perspective on the time frame, how things were going, how things were moving, right?
Yep.
So we ended up beating the first one. This one got continued out. My arraignment for this arrest, which we'll be talking about, was June 2nd of 24. I had the same public defender for my first one. So he
Oh
did
God.
he did help me beat my first one, and he was really cool.
Yeah.
He was actually a really cool dude, really good man. Prior military like me, I'm a combat veteran. He was a law enforcement officer for 10 and a half years before switching over to the legal side,
Yep.
and seemed like a really honest, upstanding dude. And he beat that first one for me, and the DA was not happy about it. But during the first trial for the first DUI, he was kicking the DA's ass, making her look absolutely foolish. And mid trial, right before he gave his closing statement, his closing argument, the judge stopped the trial and called him and the DA back to chambers. Now, I don't know if you guys know anything um, about trial, but that's highly improper, significantly improper. The only time the judge should ever include himself in a trial matter is if one party is saying something that could damage the jury and potentially cause a mistrial. Otherwise, he's to remain silent, and his job as the referee is only to ensure that proper law is being applied, proper procedures, not arguments, right? He's not to get involved in arguments. But if somebody says something about the law that's not accurate, 100% true, and they're deceiving the jury, then he may need to request him to clarify stuff like that. But otherwise, the judge is not supposed to get involved at a jury trial.
Yeah.
And he called the public defender and the DA to his chambers, so outside the sight of myself and the jury. And I'm just sitting there wondering, like, wait, he's not supposed to do that. Why would he do that? What's going on? Like, my guy was kicking ass. He's stopping the momentum, right?
Right.
And my public defender comes back out and he gets on his laptop, and he looks a little distraught. And I'm like, I'm just peeping because I'm highly intuitive with this kind of stuff, right? And I'm like, I already know what's going on. I already know that judge is kind of pissy because the judge is probably like, yo, you're defending this guy like he's paying you. If you get a dismissal, he's got an unlawful arrest lawsuit. Like, don't forget you work for the state. I'm just assuming he's saying all these things to the public defender, right? And the public defender opens his laptop and starts deleting the most important slides to the closing argument right in front of me, right there at the table. And I'm just side-eyeing watching him do it. And then when he sees me looking at him, he stops. And like he didn't know if I was paying attention or whatnot. I paid attention to everything, and I seen exactly what you deleted. And so I kind of look at him funny, like, I just seen what you did, right? And he's not saying nothing to me. He's quiet, kind of straight-faced. He ends up going, he gives his closing argument, and then he gets to a slide that is of absolute vital importance, right? And he skips right past it immediately,
What?
like immediately, like he hoped it wasn't there and he hoped it didn't get seen, and he skipped right past it immediately in his closing argument while he's giving it because he has he's doing a PowerPoint presentation to the jury to kind of close his argument, close and pull everything together. He's going over his slides. This is what happened. He's setting the foundation for the case, telling them all the facts and all the stuff,
Yeah.
and showing them some bits and parts of the evidence. And he skips right past it. And that slide was I had a witness. I had a witness that night because when me and my buddy were up in the bar, I was shooting the shit with this girl. And we were just vibing, having a good time. I wasn't trying to I wasn't dating or anything, and I had just met her that night. But I'm a funny guy when I'm drinking, and we were shooting the shit. She was with her brother, and they came up to us, and we started having drinks together, and everything was cool. Well, when I carried my buddy down to the car, we left them, and they were probably like, "Oh, our buddies are gone." Well, reason we left them is because I went to look for my buddy because he disappeared on us while we were all hanging out, and I found him in the bathroom throwing up. So I'm with him like 15 minutes in the bathroom, smacking his back, telling him, "Bro, just throw it all up in the toilet so you don't make a mess, and then we got to go because people come in seeing you throw up, dude. It's not good. That's not a good look. We can't be doing that. You know what I mean?" So when I carried him down, and then that incident happens with the cop. I fell asleep. By the way, this is like probably 30, 45 minutes, maybe even an hour has gone by. Her and her brother were leaving. And when her and her brother were leaving, she seen me getting arrested because just got pulled out and I was going through the field sobriety test and I was going through all the tests with the investigation with the cop and she seen what was going on and she's like, "Whoa, what's going on? Like, what's happening?" There they are. Hey, like brother, there they are. And so she starts talking to the cop on my behalf. Well, the cop never got her information. He didn't get her information, didn't take her witness statement. Why? Because it would have benefited me because she was my alibi that like, hey, no, he was just with me, like he didn't go anywhere. He was with me. Um, and that's highly improper of the cop. That's a violation of policy. He's supposed to get all witness statements. And so the slide that he passed was who was that witness and why did the officer not take her witness statement? What did she say? What was she a witness that was deprived of the defense? If the officer deprived the defense of a witness, why would he do that if that's prejudicial? Is that a reflection of his character, of the officer's character? And he's basically using that to kind of show the jury like maybe this officer made some mistakes and maybe they were intentional mistakes, right? Because there's no really excuse for you to, not get a witness statement. So when I seen him skip past that slide right there, and when I say it was like quick, it's like it popped up on the screen, and immediately he was like, "Oh, like quick with the button to get it off the screen,"
Off.
right,
Yeah. Yeah.
bro? And when I seen that, let me tell you guys, I knew right then and there exactly what happened in that back room in Chambers, and everything that I thought that judge did, that judge probably did. Now, obviously, it's speculation because I wasn't there, I didn't see, I didn't hear it, but based on how my public defender acted, that's what I'm going with, and I'm sticking with it. I'm never changing. That's my opinion. That's my opinion based on
Straight up. That's how you feel. That's how you feel.
how I've seen the judges act in my county, anyways,
Yeah.
for this whole process.
Yeah.
So fortunately, the jury wasn't buying the bullshit, and they found me not guilty, anyways. Even though my public defender tried to throw the case, and mind you, I did request a Marsden hearing right after that. Before the jury deliberated, I requested a Marsden hearing. I almost requested a mistrial, and I damn near threw him under the bus because I was about to say, "Yo, he just deleted some slides right in front of me, and I needed those slides. Those were prime for my defense. I don't know why he never talked to me about deleting them. That's not necessarily like a strategy point, even though he tried to put it that way." At the Marsden hearing, the judge denied the Marsden hearing, and I was like, you know what? I didn't say anything at that Marsden hearing that really threw him under the bus, because he had done some really good work for me. And I was like, you know what? I'm not gonna fuck this guy over and say what he really did because if I did, it'd be on the record, and that's a complaint and stuff, right? I'm
Yeah.
like, I'm gonna let this go and I'm gonna write it out and see how it goes. We got the not guilty. He stays with me for the next one. Um, my arraignment was the month prior to the trial for that one because my arraignment for the second was June. The
July.
trial,
Yep.
June. The
Yep.
trial then happened for the first one happened July.
Yeah.
So
Yeah.
he at arraignment he continued it out, and then we win at trial in July, and then we come back in August for the second one, He continued it out again. We go back to October. He continues it out again to November, late November. And at this point, I'm like, wait, why do we keep continuing this out, brother? Like, you're not talking to me. You won't go over evidence with me. You won't do anything. And at this point, I'm starting to get funky vibes because I just seen what you did at trial, and now you keep trying to get me to take a plea deal on the second one, and you're not communicating. You're not going over evidence with me. And so I ended up declaring conflict in November, and I got him removed, and he lied to my face, by the way, multiple times about the evidence and what happened. I told him my side of the story. He kept trying to spin the narrative for the, in favor of the DA, like, man, they got a strong case, they got the blood, and all these things, trying to get me to take a plea deal. And I wasn't having it. And I said, hey, look, man, this is what I need you to do, Jason. I need you to get this case dismissed because there's a lack of probable cause. If you cannot do that and you will not do that, then I'm gonna need to, go about this my own way. And that's what I did. And so I've been fighting it ever since.
So it's just based off of a DUI stop,
Mm-hmm.
or what they're claiming or alleging is a DUI stop.
Yes.
And then with this stop, though, why did he pull you out the car?
Your guess is as good as mine. The way the officer tried to spin it at trial was he smelled the odor of alcohol allegedly, and there were other people in the car. So to determine if it was coming from me or someone else, he pulled me out the car. He never told me that at the time. At the time of this arrest in this video, what you'll see right here is he demands my license and license and identification, right? License registration. He never articulates the purpose of the stop. I said, well, what crime did I commit? He says, well, you were swerving within the lane. I said, well, is that a crime? He's like, technically, it's an infraction. I was like, did I cross the line? I said, anytime. By the way, this video is not complete. I don't know if we get it. If I should mention anything about that, Cam, or do we want to do something about that later?
Why does he pull you off camera though?
Exactly.
I don't understand that. And
Exactly.
in a darker area.
Exactly.
It's
I don't
relevant.
understand that. It
It's
is
relevant.
relevant. It is
It's
relevant.
totally
It's
fucking relevant. They had want. That's why he pulled you out of that car. Want. Just
well,
remember
Yeah.
that.
why?
Want.
I just don't understand why they pull him over to the darkest spot. Like you over here in all the light where you can easily
Yeah.
see everybody. Then you pull him over here and he's standing in front of the camera and he tells him even to come further. And you can see it because you can see how Michael kind of just stops here for a
Stop.
second.
Yeah, because I'm like, oh, I want to be in front of
Look,
this. Him.
yeah, boom, we're sitting here talking. And he's like, come here some more. So Michael's like, oh, man. That he completely taking you off camera. So it is kind of odd there. All right, so this is what happens. You end up going to jail for DUI.
Yep.
And then you go to jail for DUI. You're getting these continuances. You got the same public attorney or public defender. He's still looking at the whole situation, but he's not doing anything for you on this one. You take it over yourself
Yep.
and you start making some actions. And that's honestly, I think you had already done some action on your own.
Yeah.
Before you even came to me because this was last year when girls were still in school.
Yeah.
And yeah, you ended up, I think at that time too, you was even talking about a blood draw split. Like what's going on there and how you end up, because they pulled your blood.
Yeah.
So then they had the blood. They were saying that there's a certain level. What did you end up doing as far as a split is concerned, and how did you make that occur?
So, in terms of the blood split, I requested a blood split with the DA, not through a filing on the private side, so to speak. I got the DA to sign that they'd agree to the blood split. Now, to get into about the blood split and how it worked in my county, it was very weird, and I didn't like how it worked whatsoever. Accordingly, in my county, I had to send this letter of agreement that the DA releases the blood split from the lab to allow it to go to another lab. And I had to contact a secondary lab to do the blood split first. But I don't know if you guys have ever tried to find a criminology lab that does testing, evidence testing, right? When you try and type Google, it's not helping you. There ain't nothing there. There's nothing there. They don't advertise this shit. You know what I'm saying? And they tend to only work with law enforcement. So it's like it's almost like they keep private from pro se's. I didn't have any good luck finding a lab nearby that would do the blood split on my behalf. And if I did find one, I'd call them and said, oh, and they'd say, oh no, we're sorry, we only work with law enforcement. Or if you're a licensed attorney and you have a specific system that we could work with, then we could work with that. But we don't work with just average Joe Schmoes, basically.
Sounds like
Um,
a lawsuit to me.
yeah, really fucking well. They have the right to refuse service. But it was just really difficult. So I contacted the lab that did my blood, and I said, "Hey, who do you guys work with for a blood split?" And they gave me two labs. One was up in North California, and one was all the way in Chicago. And I was like, "That's fucking weird. One's all the way in Chicago." I'm like, "Well, we're not going to send the blood there. That's more travel time and more room for error on transport." You know what I'm saying? So we'll do the one up north in Northern California. And so then they're like, "Okay, this is what you have to do. You have to get permission from the DA. Then you have to send that permission to us via mail and with a money order." The money order was $90, and then we'll release the blood to that straight directly to that lab. We cannot release it to you, and that lab will do the testing, and then you can contact them for further processes. Right? Mind you, my when I asked my public defender previously to do a blood split, he said it would cost $4,000, and
Jeez,
that he'd have to get permission from the DA. This is when he lied to my face
jeez.
and made me really distrust him. I'm like, hold on, it would cost $4,000 to do a blood split, and we have to get permission from the DA who's prosecuting me. Isn't that a conflict of interest? What kind of bullshit narrative is that, right?
Right.
So then I did it myself, and it was $90, guys. And then if I wanted an expert witness that from that lab, if I wanted to subpoena them, have them testify on my behalf, they charge 150 an hour. That's guy, and that includes travel. I'm like, guys, that's not $4,000. You know what I'm saying? We're talking about maybe 3 hours of that witness's time, maybe five, right? It's like $1,000 at most. So the lies just kept piling up, and I'm realizing as this is going on, I'm like, man, it's
That's what
just
that's what they charge though.
uh yeah, yeah,
Yeah,
that's what
yeah,
they.
yeah, yeah. That's what they
But
charge.
nonetheless, so we sent the fucking request, we sent the thing, they got the thing, they sent the blood to the other lab, and I was in email communications with the other lab. And the only way my blood split worked is they sent me an email of a certified blood result from somebody saying it was 0.084 or something. I don't remember. I have to pull it. But it was still over the limit. And I'm like, it's impossible, dude. It's impossible. It's impossible. So context for you guys, because we didn't go over this. The arrest happened at 2:30. My last consumption, the bar closed at 1:30, kicked people out. We hung out outside the bar just shooting the shit and just kind of talking anyways for about 30 minutes before we started leaving. And then so the arrest had happened at 2:30. They drew my blood at 4:30. So my last consumption was no later than 1:30 because they kicked everybody out at 1:30. And I was pretty much done before that anyways. It was one drink. And I had been sipping it for about an hour and a half, probably. It had just been sitting in my hand. I was mainly just mingling, and I just like having something in my hand. And the blood was at 4:30, and yet somehow my blood was over the limit. So that's the time frame that you guys have to work with, right? One drink at maybe 10, one drink at maybe 11:30, and that's it. And then arrest is at 2:30, blood draws at 4:30, and somehow the blood result that they got was 0.093. And then when I sent it to the other lab, somehow it was 0.084, whatever it may be, still over the limit. So that's how my blood split process worked. It did not seem professional. It did not seem um it did not seem really capable of a real legal process, right? It's like email communication. You didn't send me the results in mail. You didn't do the blood split on camera. There's no in-camera review. There's no and by the way, I didn't know about in-camera review. I didn't request that when I sent the document. The document that I sent was pretty narrowly tailored. This was before I got really educated and understood that there's a lot of really cool evidentiary processes that you can ask for, and in-camera review is one of them, and you definitely should always request an in-camera review of testing. There needs to be video evidence of them doing the task, because if a piece of paper that says I certify that this number is true and correct is all it takes for them, then they could lie, and that's just, I mean, we can't act like it doesn't happen, right? So you always want in-camera review. I never got that. And I never got to pursue that further in evidentiary, because soon after that blood split result came, I ended up bringing up my accusation that the evidence was tampered, spoliated, or audit or manipulated in some manner. And as soon as I raised that issue in writing, the next day I was held in contempt, thrown in jail, and assigned a public defender.
So it seems as though at this point, pretty quickly after getting out of the car, they already had your ass arrested or hemmed
Yeah.
up. You can see they're over here searching, doing a search,
Yep.
and yeah, pulling stuff out the pockets. So, all right, they had somebody else pulled over too. That was kind of odd. Now everybody's showing up.
Look at my parking versus that person's parking.
Yeah, yeah, that's for sure.
We didn't show you guys the travel portion. I was weaving within the lane very slowly. I was drifting back left and right. Um, my alignment was a little messed off, but honestly, I was looking back, talking to the homeboy in the back seat on occasion while he's talking to me, and he's trying to show me how he was doing something at the bar, and I was distracted. So at the time when he pulled me over, I was like, "There's no reason you pull me over because you don't see yourself swerving if you're looking backwards. You know what I'm saying? You don't see yourself drifting slowly, and it's not erratic. It was very very slow. I mean, very very slow.
Conversational wise, yeah.
Yeah, and so when he pulled me over, at first I'm like, dude, why did you pull me over? Like, I didn't do anything wrong. I wasn't speeding. I didn't. There's no lane violations. If I switch lanes, I use my blinker. All these things. And so at the time, I didn't think that he had any merit to his stop whatsoever. So I was already pretty on defense. By the way, I was already facing a fucking unlawful DUI in the first place. So I knew that this guy followed me from Old Town. And during the detainment, a lot of stuff is not in this video. Now I don't know how they extracted it out or suppressed it. Dude, they did a fantastic fucking job. This is not the first time they do shit like this because you could not tell that this video was manipulated or altered. Like you just couldn't tell if you watch it all the way through. The only reason I could tell is because I'm like, wait, this incident for sure happened and it's not here. Now there was an incident where we went from the right side of the vehicle to the left side of the vehicle at one point because he went to the left side to talk to one of his partners and I followed him over there and I'm like, hey, is this your sergeant? Because I asked for a sergeant. So me asking for a sergeant is not in here. Him conducting the FST is not in the video. Um, a lot of the conversations that were had are not in the videos. And I know this because I was there and I remember the entire night like it was yesterday because it's a traumatic event. That's that black guy right there. That's Officer Jackson. Officer Flores to the right of him is the one that arrested me. Officer Flores, when I asked for a sergeant, said that Officer Jackson was his sergeant. And so I went and talked to Officer Jackson. Um, Officer Jackson asked me if I would do a breathalyzer test, and I said no. This gentleman hasn't even articulated why I'm pulled over and what crime I've committed. Right now, he's just saying it's suspicion. I don't know what that means. And so uh, the officer Jackson's like, "Well, will you do a breathalyzer test?" And I said, "Well, no. Why would I do that? I don't need to do that. I'm clearly not intoxicated, man." He's like, "All right, do what you gotta do, Officer Flores." And he said, "Do what you gotta do, Flores," and walked off. And I'm like, wait, what the fuck? You're the sergeant, and that's how you act? That's how we deal with things here. Um, After the arrest, when we got back to the station, the actual sergeant came and introduced himself as Sergeant Barajas, and I asked the sergeant right then and there at the station, "Who's this guy?" And he said, "That's Jackson." And I said, "Who's Jackson? Is he not a sergeant or a supervisor or a lieutenant of any kind of leadership rank?" He said, "No, not at all. That's Officer Jackson." And so I looked at Jackson while Flores is at the computer trying to get a warrant. And I said, "Jackson, why did you say that you were a sergeant during my detainment when I asked for a sergeant?" And Flores, why'd you tell me he was your sergeant? And they were quiet. And then the sergeant's like, "Okay, well, look, this is what we're going to do, right?" And just interrupt and change the subject. Now, all of that is out of the video. So anything that lost them their qualified immunity, any like that's a lie. That's a blatant lie that Flores said to be deceitful. Boom, qualified immunity is starting to go. Then he arrested me without probable cause. Boom, that's another factor for qualified immunity. Then he didn't follow his CHP policies and procedures. I know this because I pulled those and I went over them. And during the FST, he did not follow his policies and procedures. He said, because I said, you know what, I'm not going to blow for you, but I'll do an FST to prove to you that I'm fine to drive home because clearly you want to test my motor function skills. I'll show you that I'm fine to drive home. So he initiates the FST and he says, "Look past my right shoulder and follow my right finger." And I said, well, which would you like me to do first? You just told me 2 commands at once. And he said, that's it. Turn around and arrest me. That was the FST, guys. That's how it started. That's how it ended. It was that quick.
Was
said,
was that part
Michael, I think
was that part caught on audio?
Nope, it's not in the video.
Neither
Now,
that part. Wow.
Yep. I'm telling you, everything that they did wrong, everything that could be used to prove the cops like dishonesty, anything I could have used to show that the cop didn't follow his procedures, anything that would have lost them qualified immunity, it's all gone. And by the way, you guys know this. You should know this if you've done some legal work. In evidence, well, at least for the CHP, a DUI misdemeanor arrest is considered a significant event by definition from their own CHP policies. Their policy for a significant event is that the recordings remain constant and not interrupted whatsoever. From start to finish, from start to booking, there has to be recording. It has to record the whole incident, so there's a totality argument available, right? The evidence they gave me, there's a 12-minute gap.
Dude, doesn't that show on the
Yes.
counter?
Yes.
The minute counter, it shows.
What's that?
The minute counter has got to show a gap. They
Yes.
can't fake that, can they?
No.
Look at
what
what the state said real quick.
Yeah.
In one of their oppositions.
This is their
Listen.
only opposition.
This is so funny though. It says,
Context. This
additionally,
is their only filing, guys. This is the only filing through from charging me through now we're in the appeals. They've never filed anything other than this.
watch
Go ahead,
this. Additionally, the defendant argued, quote, the arresting officer failed to indicate any actual signs of physical impairment in the arrest report, which is evidence that no impairment was present at the time of the arrest. This assertion is blatantly and plainly incorrect. The video shows. Like,
Yeah.
what are you talking about is incorrect. The video shows.
Yeah,
like,
why aren't they pointing to like some record evidence that shows this? Like, you know,
Yeah.
No record. There's not a single record reference in their pleading.
It's like
Right.
when a kid says and you know they guilty, you just want to do it.
Yeah.
Like what you talking about? Oh
No.
my god.
You.
Yeah.
Yeah. So guys, remember, by the way, when I was going through this,
Wait, one more. The next sentence too. To start, the defendant is not the one responsible for determining what signs and symptoms of impairment were present when he himself was arrested for driving under the influence. The video, like,
hey,
they would be shown, right?
Cam, show him
Like-
the warrant. Cam, show him the warrant.
Damn, this is crazy, bro. Like,
Cam,
Bro,
wait,
are you-
go back to that. Cam, go back to that.
oh.
The warrant's right underneath it. Scroll down a little bit.
Okay. Where to?
What page are you on?
What line? Well, this is the conclusion. I'm on page 8.
Yeah, keep going down. It's attached
Okay.
as an exhibit.
Okay.
It's attached as
Okay.
an exhibit.
Okay.
So go past that. That's the arrest report. Doesn't matter. Post hoc, drafted 9 days after the arrest. That's the arrest report. Keep going down. It's a little further.
No field sobriety tests were conducted, by the way.
Yeah, and that was a lie, and I got the officer to admit that on the stand.
Okay. Property. Okay.
Keep going.
Search warrant.
This is a search warrant return. Go right underneath it.
Okay.
This is the search warrant. Keep going.
Okay.
Right here is where we get good. Attachment A. Keep going.
Okay.
I think it's 2 pages down.
Okay, cool.
Remember, right here. Boom. Go up. Right here, this page. Remember, the defendant is not responsible for determining what impairments exist. Cam, scroll down to their check boxes.
It's so funny, bro. It's like the video.
The video shows right there to the bottom right, guys. What's that say? Coordination, normal. Coordination, normal. Hold on. Demeanor, uncooperative, argumentative, and insulting. I don't know if you guys watched the video that we just watched. I don't think that I was uncooperative, argumentative, or insulting because he told me to get out the car. I initially said no. He said, now I'm ordering you out the car. And I said, well, fuck. All right. So I get out the car and I followed, went to where he wanted me to stand. And I had conversation with him. Was I argumentative? I mean, is advocating for your innocence argumentative? I don't know. Was I insulting?
Exercising your rights, invoking your rights
100%.
is argumentative and
100%.
uncooperative.
And then did I insult him? Not once did I insult him during detainment. Now, I did insult him when he was drafting this.
My boy's got the
Actually,
normal condition, y'all. Look,
yeah,
look. He's got
it's
the
boom. Case
not
closed, guys.
unsteady, not use
Oh, oh,
support. You're standing all on your own. You wasn't staggering.
go left. Go
Yeah,
left, Kim.
oh,
Same
bro.
page. Go left, Kim.
Speech. Okay.
Right here. Scroll up a little bit. Objective signs of impairment. What do we got there?
They, um, they just say
Uh,
odor.
no, scroll
So
up a little. I think it might be right above it. Scroll up a little bit more. Vehicle swerving in lane. This is the only contemporaneous affidavit, guys. This is the only sworn document that was filed by the arresting officer the night of. Now, remember, Beck versus Ohio says that it's the information is within the officer's knowledge at the moment of arrest, right? Not what he thinks. It's what he knows at that point of arrest. If there are enough objective facts to prove that a crime was committed or was about to be committed, anything stated afterwards is barred from Beck versus Ohio. Now, in this document, he says vehicle swerving in the lane, and their opposition, they adopt his arrest report narrative, which his arrest report was drafted 9 days later. The arrest was on 4/23. The arrest report was drafted on what was it? 3/03. So 2/23 the arrest, 3/03 the drafted arrest report. 9 days later, this officer went through the evidence, watched it a few times, and said, "Hey, Sergeant, sit down with me. We got to figure this out because I fucked up and I know it." And they decided to do that. So this is the only document that really fucking matters. This and the video. This is the only evidence that matters. The arrest report.
isn't your video the one that has two audio tracks? Is that
Yes.
this? Is that this one?
Yes.
Yeah, you got clear evidence that it's been tampered with.
Oh, brother, wait until we get into the CAD report and the video
Oh,
testing
okay.
box.
That
all right,
that
let's see.
that bro, and I swear I've never seen it to where it's green down here on the timestamps and numbers.
No, never, bro. And
Like
and
that's
I'm
like one of the
telling
most
you,
weirdest things to me.
they did that themselves. I'm telling you, they took out the real time and number and evidence, and they did it themselves. Guys, the detainment was not 15 minutes long. It was not, but they made it to where it was. Why? Because if you can't establish probable cause within 15 minutes of a detainment, then it's an unlawfully prolonged investigation,
Like they
right,
didn't
Cam?
have no body cameras?
No body cams. It's CHP. They had body audio, but they never
They
produced
don't
it.
have a cage cam?
Yes, they do, but they didn't produce it.
Real quick cut in. My CHP video had the green numbers as well. And at the time, this was August 2024. They didn't have body cameras at that time. They only had the dash cam.
So maybe it's a CHP thing.
So yours is green too,
I believe
Zach?
so. Yeah, it's same green numbers.
Okay.
It's a
Okay.
CHP thing, I believe.
Okay.
Yeah. So, in that
Watch out, bud.
affidavit,
Move.
in
My
that
bad.
search warrant affidavit, guys, you seen clearly it said vehicle swerving in lane. Guys, there's a case U.S. versus Colon out of the Ninth Circuit, which strictly held that slight deviation within a lane is not a violation of the statute. So on appeal, I've already got an appealable issue it's almost concrete, like you can't even dispute the evidence. Now
Okay.
now the officer tried to testify. Oh, right there, you passed the line. Right there, there's a line violation. In U.S. versus Colon, it says even a slight straddle of the lane momentarily is not a violation.
Yeah.
It's entirely within the lane. The line is still the lane. As
Yeah.
long as you didn't cross that line, as long as it wasn't erratic, it wasn't, if it was a de minimis movement, then it's
Right.
not a violation. Because if that were the case, then average drivers who just fail to retain a perfect vector down the road would be subject to investigation if we ruled anything else. That's what the Ninth Circuit and U.S. versus Colon said. So we already have a reversible error in the traffic stop. There was no reasonable articulable suspicion for the traffic stop. So I argued this stuff at the evidentiary hearing, guys, and I have the transcripts of that now. I don't know if I've shared that with Cam yet, but I could never get transcripts. Even though I had asked for them, I could never get transcripts, even though I was deemed indigent by them assigning me a public defender. So the court had already held, hey, we'll give you a public defender in the very beginning. That means you've accepted my indigent status, and I'm entitled to everything that somebody who has to pay for it is. And when I fired my public defender, I asked specifically that I would like all transcripts and this, that, and the third. I need all this information. They would never give me anything ever. There was no record. The only record that I was ever subjected to was the record that they created and they narrated in my whole case, right? When the judge ruled on the 1538.5 suppression motion, the judge is supposed to put his ruling on the record, right? Well, they claimed that the record that he put it on was the transcripts, but the transcripts are just transcripts. They're not a judicial order. And I can't appeal a non-existent judicial order. And for a 1538 suppression motion, the judge is supposed to put his ruling on an order, because I have to be able to have that so that I can possibly submit an interlocutory appeal, which is a intermittent appeal, right, on that specific issue. And I didn't get to do that because the judge never submitted his order ever. There's no record of it. It doesn't exist. That's a violation of due process. I mean, guys, the stuff that I was dealing with, I'm in the firm belief that the whole judicial county of Riverside is absolutely, disgustingly, atrociously corrupt. That's the only thing. If I could sum it up in my own opinion, it's the only thing I can come up with, because no judge ever helped me. When I got the officer to admit that he lied about the FST, the judge did not look at that officer and said, "Sir, why would you lie on a sworn declaration? You know that's perjury." That's what a fair and unbiased judge would do. You know what the judge did in my evidentiary hearing? He skipped right over it like it didn't matter. When I got the officer to testify that he deprived me of evidence by not conducting that FST, the officer said that's irrelevant. It doesn't matter, because you didn't have to do an FST. That was his like logical reasoning. You're not required to do something that could be used against you, right? So that's a non-moving factor. I said, how is that not? If I told the officer I would do an FST, then I volunteered to that. Then I'm entitled to that, because that evidence could be used against me, but it could be used in my favor also. And the judge said, we're not going to worry about that right now. I'm focusing on something else. I
You
mean,
know what's you know what's important here too is even their own statements kind of
contradict themselves.
bite them in their own ass, because it says, quote, whenever any roadway has been divided into two or more clearly marked lanes for traffic in one direction, a vehicle shall be driven as nearly as practical
Yes,
entirely within a single lane,
that's the
and
law.
shall not be, quote, word, this one's big, moved from the lane, meaning
Yes.
again within the lane, until such movement can be made reasonable safety, meaning like,
Yes.
a blinker, and he used his blinker when he
Yeah.
needed to change lanes. When he didn't and he was within the lanes, he was perfectly normal. So now they come on to say weaving within a lane provides an officer a reasonable cause that a stop is based on suspicion. But it doesn't say that here.
No, not at all.
So
And you guys, I didn't get to respond to this opposition because they filed this on Friday, just like the week before the hearing, the evidentiary hearing. They filed it Friday. I didn't get this mailed to me until the day of the hearing, after the hearing. I got home from the hearing and I had a packet at my front door from FedEx, and I opened it and it was this packet. Now they did send it to me through email the Friday prior, like Friday evening, but I work weekends, so I didn't check my email that Friday evening because I didn't have any knowledge that they would communicate with me via email. Nobody told me. No attorney reached out to me and said, "Hey, is it okay that we communicate with you via email?" Like the DA didn't call me and say, "Can we communicate with you via email?" I didn't get none of that, right? And so I wasn't thinking to check my email, that Friday. I didn't see the email until the following like Tuesday or Wednesday. And I was like, "Oh, what the fuck? They emailed me this." I was like, "Well, fuck, it's too late for me to even respond at this point." I'm like, "The hearing's in 2 days."
bro, when did your car weave and almost hit a curb?
Hey, it didn't. I'm not
What
even gonna lie, bro.
what just happened here? They literally put in here, in Auburn versus Department of Motor Vehicles, the officer conducted a traffic stop after observing the defendant's car weaving and almost hit a curb. Where's the curb? He was on the highway, homie.
I think they were trying. Yeah, that's a moot point.
What do you mean it's a moot point? That's what they brought forth in their argument as far
That's
as
that's what I'm saying. Their argument was moot. Like I should have attacked that.
what the hell?
I didn't get this. I
That's a
didn't get this.
fabrication.
Yes. Yes. Cam, everything they've done in my case is fabricated,
Oh,
lied.
I'd have been on their ass about this one. This one wouldn't have
Oh,
sufficed. I would have hit them hard. I'd have been like, y'all
yeah.
kept saying it was a curb. There was no curb.
Yeah.
So
Where's the curb?
where's the curb? That's the justification.
Yeah. I'm going to on appeal. Hey, me and you can have fun on our appellate brief about this. Um, yeah. Should we show them the chain of custody logs now?
Yeah. Well, what do you want to go through as far as court is concerned? You got to go through, especially the point where this dude got loud and he got
Yeah.
rude.
Yeah. Well, I think we should show them the chain of custody logs first because we want people to understand why these kind of things are happening to me. At least
Where's that at? Where's that at?
I want them to understand why these things are happening to me. Let me scroll down. The chain of custody logs will be go to the motion for limited remand.
Just what day? What date?
I'm looking for it. It's
Motion for what?
7/28/26. Scroll up a little bit. 7/28/26.
I ain't got no 7.
I think you're at the top. You need to go down a little bit.
It's December. What you talking about?
Yeah, if you're in my communication thread, it's like
What?
middle.
Okay,
in the
but
middle.
what day? See, there's December 9th. What day?
The date on my email is here. Let me.
No,
There,
I'm in Discord, broski.
I'm in Discord too, brother.
Oh, well, what day
Scroll
is it?
down. Scroll down. You're at the top. Scroll towards the middle. Around there, right there. Now slow up.
You got a lot of drives right here. 7 Ferretti hearing, 5 probable cause hearing. Here's all those videos.
Oh, scroll down. We're down below that.
Okay, we're down below that. That's where all
Yeah.
the he screamed at you is at, right?
Yeah, I there's a lot of communication. 7/28 is the date you're looking for.
7/28 is the date that I'm looking for.
Yeah,
Oh,
so
oh.
the date of the chat box. You know what I'm saying?
Oh, no, I don't know what you're saying. Now you lost me again, bro. I've been smoking this morning, bro.
Here.
What are you talking about?
You got to
7/20?
scroll up. You passed it. You passed it. You're talking about Michael. You're saying that you posted something on September 28th, 2025.
July 28th, 2026, this year. I just sent it to you,
Sorry,
Cam.
yeah, July.
Cam, I
July.
sent it to you in a direct message.
Bro, I don't. What are direct messages? Look at all. I never check these direct messages. Okay.
Motion for limited remand.
Gotta do this one. Okay. All right. What's going down here?
So y'all, this is my draft now. All right. This is how I work now. Right. I got some guidance with Cam. This is how I do my work now. Now, Cam, this motion, guys, is a motion for limited remand for factual development. Why? Because after the conviction, I submitted a public records request to the CHP asking for all documentation and records pertinent to evidence. That means chain of custody logs, CAD logs, everything. I asked for everything. They bullshitted me for a while, but then they gave it to me. And when they gave it to me, let me tell you guys, when they gave it to me, I went through it and I said, boom, you just gave me my lawsuit against every single one of you. So if you guys ever want to look at this, it's in my Discord. I could send it to you. Cam, if you go down to Exhibit A, they'll see the I'm just gonna like brief over this so that you guys, if you ever check it out on your own time, because we ain't got time to go through it all. But you'll understand what this document is for, what it does, all that good stuff.
You talking about the forensic evidence
Yes,
integrity
matrix.
matrix? Okay.
Yeah.
So keep going. These are all your points and authorities, right?
Yep.
Your
My points and
memorandum?
authorities, prayer, all that good stuff.
Yeah,
Got some
okay.
footnotes in there.
Good. So we got the memorandum, got all of our points
Usually
and
I would have
authorities.
my captions single spaced, by the way, for my sections. Those don't need to be double spaced. Usually I would have them single spaced, but I was trying to get this shit done real quick and I wasn't going through all that like minor details. So that's my paraphernalia. If you got to have your verification. So, guys, this is what I did when I got my CAD report, my chain of custody logs, and all that stuff. Me and my AI, I went through all the CHP policies for retainment and everything, and I uploaded the logs. And this is what we get, guys. There's a 12-minute recording gap at the very top. There's local purge activity um pre-charges, right? Before the DA even initiated charges, there was a purge event 3 days and 5 days after the arrest. Now, if you guys don't know what a purge event is, I'm right there with you. I don't fucking know what it is either. But I know the CHP is not supposed to have any purge events whatsoever for their evidence at all until the appellate process has been exhausted.
Now let me ask you and just play devil's advocate here. What
Yeah.
if they say that like, oh well, that purge event triggers us pulling everything from what's currently on the record? What if they ever tried to play that angle?
Restate that for me.
Yeah. What if they tried to say like, okay, this purge event that's labeled on here is us pulling everything from the record?
It wouldn't be that. It
No,
wouldn't be that.
purging, they're clearing, they're deleting
Yes,
data off
deleting.
here, and there's two
I
locations. You
know.
delete it from local storage and cloud and
Yes.
cloud storage.
Okay, and that's why I say that because I'm just playing devil's advocate. I'm saying,
Yeah.
what if they
So
come and say that as an excuse though?
So this
What
is
are we
what
going to be able to do to say no?
I'm
That's
a-
not how this works.
I'm gonna tell you exactly what we do, Cam. We're gonna subpoena the Safe Fleet coordinator expert that is a part of the CHP company. I'm gonna get their information through a public records request. I'm gonna get their name, identification, everything, and then I'm gonna subpoena them as my expert witness.
Yeah.
And I'm gonna ask them, what does purge mean by definition in the Safe Fleet manual? And they will have to give us the definition of what it means.
Yep.
And that's how you prove a point.
And that's how we prove things. You're going to get their experts to testify against them. That's what we're going to do. And I'm going to subpoena every fucking person that could potentially be tied to this. Every single person. I'm going to get all their names. I'm going to get who was the evidence coordinator for making sure that the evidence is safe, right? There's always some supervisor who their duty is to ensure that the evidence system operates functionally. When we get to the chain of custody logs, guys, you'll see that the purge event that happened 3 days and 5 days after arrest was done by a designation system, not a user. The user was system. That tells me that they went in and they manipulated their system's auto purge setting to effectuate then and there. Because there's an auto purge for a year, and that auto purge system is set in stone. And that system can be extended. The purge can be extended so that it doesn't purge after a year. It can be extended.
So this right here, I guess, is what the interval you're speaking of.
Yes.
Okay, and you brought it forth.
Yep.
Under Part 2, which is the forensic evidence integrity panels.
Yep.
And again, the purpose of this part presents the 5 consolidated forensic panels identifying the principal conditions affecting authentication, preservation, chain of custody, and evidentiary completeness. Each panel distinguishes the object record condition, governing policy, documentation required for reconciliation, and resulting authentication status without asserting misconduct. Keeping it cool, saying, hey, man, I'm not saying that right now, but let's just look at it for what it is. Okay.
The objective record. What is it? What does it show? What does it mean? Is there and this is the most important question, is there a need for factual development? No judge can look at this. No investigator, no DA, nobody can look at this and say, no, there's absolutely no need for factual development whatsoever.
Yeah. What's going on?
So we have the CHP policies. I cited the CHP policies which dictate that it's a violation.
They pulled a Hillary Clinton on your ass.
Yeah, yes, sir. Yes, they did. They did a lot more than just that, brother. So there needs to be authorization logs for every action that happened.
Yeah.
CHP authorization log 36D, 36F, and then there's another one too. There needs to be, if anybody accessed the evidence, they need to submit an authorization request, and then a supervisor that controls the evidence, who's supposed to keep the evidence safe, is supposed to approve that request and grant that person access to the evidence. They are not supposed to download the evidence ever. They're not supposed to download the evidence. They did it multiple times, many, many times. They're not supposed to download. It's all supposed to stay in one local stored unit. It's supposed to be safe in like a vault. This unit is supposed to be a vault. You're not supposed to download it because if you download it to a cloud, to a separate section, then we don't know what you do with it in that cloud section. There's no chain of custody logs in that cloud section, right? You could be doing whatever the fuck Joe Schmo wants to do in that section. So their policy says you don't download it. No downloads are to outside sources is proper. You know, all these things, and there's like,
Bro, they literally got their own local purge on this thing a couple days
yeah,
after the arrest.
yeah, yes,
On this specific body camera. It's like, how much more telling could that actually kind of
a
be? It's
hundred
kind of
percent.
weird, bro.
Michael, can I ask you something? Were you saying that they cannot download body camera footage to outside sources?
No, they can, but they need an authorization form.
Oh, okay.
They can't without authorization.
Yeah.
Okay.
And they
So
don't
need
have
the chain of custody.
and they don't have the
Okay.
authorization forms because I asked for them. So once I got the evidence, they gave me the bare minimum. Then I said, okay, I need all your policies. Then they gave me the bare minimum policies. I said, man, fuck you. I'll go online. I'll get your policies myself. Because it was taking like 20 days from me asking for something for them to even like consider giving me anything. And then they were taking 30 days. I started asking for things in March. I didn't get anything until like what, January, March, April, May, June. Like it took 2.5 months for me to get anything. So then once I got the logs, I ran it through my AI with the policies that they gave me. They only gave me 2 policies, and immediately it flagged some issues. And I was like, yeah, I see those issues too. So then I went online and I got all their policies, guys. I'm telling you, I have a tab that has about 50, 60 CHP policies. I don't need all of them. Some of the policies that I got I'm gonna use in future actions, right? But I got all the policies that were as it's pertinent to the evidence. And then I uploaded like 6 policies pertinent to the evidence into my AI to go over it with me and tell me what sections are most important to our specific cause to identify what's going on with the issues that we flagged, right? And we ended up doing a lot of work. I spent days with it. And we got we put this whole thing together. And as you can see, it's pretty substantial, guys. It's about 20 pages. And every single little detail then takes us to another detail. Okay, well, if this happens, they have to have this. And if they don't have this, then they have to have this. You see what I'm saying? In simple terms.
Bro,
So,
everything's on your video updates on the PMs. Everything's at either 3, 6, or 9. So you got 3, and then you got 3, 6 again, and then you got another 3, and then 39, and then with the 4 and the 2 ones over here, you got another 6. It's so weird.
what page are you on?
Bro, page 9 on the
Okay.
video 1 and video 2 updates.
Yeah.
Everything's of a 3, 6, and 9 numerology. It's kind of
Yeah.
crazy too, because again, this is really deep, bro.
Yes.
Doing really good on the clarifications on
I
everything.
went
Like I
very
said.
deep.
But I need to also ask too, just so everybody's kind of knowing what's going on here as far as what avenues you've had to take, because you okay, so this is going to what right now? Because you said this is kind of current, right?
Yeah.
What all are we looking at right now, and where did you submit this to, or where's
So
that?
I submitted this in the appellate division. So guys, what happened was, let me
Yeah.
give them a quick breakdown on my
There you go.
procedural trial posture, right?
Yeah.
I didn't have this evidence when I raised the issue, but I knew that the evidence was omitting that the dash cam that they provided me was incomplete because the FST is not on there. All the things that I told you when we were watching it that's not there, I knew it wasn't there. And when I questioned the officer if it happened, he admitted under oath it's in the transcripts that yeah, it did happen. So I was going to use that to prove that it's incomplete. Hey, I need an evidentiary hearing to address this issue. Now, I don't want to go over my filings when I did that because they're fucking awful. I got yelled at by the judge. I got yelled at by the judge when I was trying to get my case dismissed.
Was it this one? Was it this one?
It might be.
Which one is it?
July 14th.
No, this one's on the 3rd. This was July the 3rd.
So that was me filing the documents. The clerks would like try and give me the runaround about not taking my documents. So I started recording everything because if you don't take my documents, if you don't file it, then we got an issue.
So you got 714 part 1, 714 part 2.
So 714.1 at the
Yeah,
end of
that's
that is
fine.
when he yells.
Yeah,
Yeah.
that's what I thought.
So just go to the end of it.
Sir, you didn't. But it's not. I wasn't finished. You interrupted me, sir.
Let's just go back a
my-
little bit.
Yeah.
Let's just go back just a little
I
bit.
get interrupted.
Everything that Mr. Carey has said has essentially been ruled upon previously. The court has established jurisdiction by virtue of the alleged crime taking place in Riverside County.
Objection. For the record, I object, sir. You didn't. But it's not. I wasn't finished. You interrupted me, sir.
It's my turn now.
Is it my hearing or is it your?
I don't know, but I hear somebody in the background say, "Ooh." I don't know
Yeah,
if
that
that was you or.
Nah, that was some there was a lot of people in there, bro.
County.
Objection. For the record, I object, sir. You didn't. But it's not. I wasn't finished. You interrupted me, sir.
Ooh.
I stayed calm. I said, you interrupted me, sir. Do I have a right to be heard in this hearing? And he said, we're on recess and ran off the bench, y'all.
My turn now.
Is it my hearing
Then
or
he
is it your
left.
hearing, sir? Do I have a right to be heard?
Ladies and gentlemen, we're in recess.
Respectfully.
Ran off the bench.
For the record, the judge has left the bench.
Yeah. So
So
after,
right then,
Then you can
so
story
right
up
then
on
and there, right then and there, I don't want to get into any like crazy theories, but right then and there, when the judge abandoned the bench, from what I've seen other people do, and I never practiced it, but when he abandons the bench, he abandons his authority. So you can't,
Yeah.
a judge can't leave the bench unless you've ruled on the matter or you have permission and consent from both parties. So I've researched this. A
So
judge
it's-
can't, he can't
it's
leave
under-
the bench.
It's under Robert's Rules of Orders and parliamentary rules. The judge has to respond to a question, and if he does leave the bench without ruling on something, you can hold him underneath. You can hold sanctions against him.
Yeah. So again, that's what I'll be doing that eventually, but I never got the transcripts. I asked for the transcripts and I never got the transcripts. When I did get the transcripts, they don't show me saying, for the record, the judge left the bench. But I've got this video. So
I have a serious question on that real quick.
yeah.
I believe that same thing, if we're talking about like an actual court of record, does that, I've never even thought to look into, does that actually apply to administrators?
Yeah, absolutely.
Yes.
Okay.
Absolutely. And so you guys, you got to understand, a judge as an administrator is acting as executor de tort over your estate, right? He's acting as the
What does that
administrator.
case on tort mean? What does
Executor
case
de
on tort mean?
It's executor de tort. I'd have to pull the legal definition. I have it somewhere. Let me see.
It's important because that's one of the 12 presumptions, and I've looked and I don't fully understand case on tort.
You got to pull it from Black's Law.
I did. I read it in Black's Law, and I still didn't fully get it. It just didn't seem to make full sense to me. But I know the language.
So
all-
the judge is the referee over
Yes.
the administrative hearing, right? He has three obligations, right?
Yeah.
To hear both sides, to answer all questions, and to rule fairly and impartially.
Yeah.
If he can't do one of the three and he leaves the bench, he fails to perform his duties, which underneath Robert's Rules of Orders, there are certain protocols you have to do in order to hold him sanctions and move forward against him.
I wonder.
which one is
if
showing the purge, Michael? Is it the retainment policy? Which one is it? The purge.
Let's see.
Media chain of custody report 2.
Yep, that one.
This one?
Yep, media chain of custody report.
It says video.
Yep,
Okay.
because it's the report of the video.
Michael, I remember us a while back. We done a video on your video where you got arrested, and from the beginning to majority way through it, we called out a bunch of stuff.
Yeah. Yep.
Yeah.
A bunch of stuff.
like- I remember when Cam he brought up there's only one way he could demand you to get out of the car. Yeah, there's so much fraudulent crap. I remember that video.
Yeah.
And now that we're doing it again, these guys are finding totally new stuff.
Yeah, they know they messed up. So guys, I'll give you a little context. Why would they do all this to somebody? Why would they go through all? Why would they commit all these crimes? It's a felony to tamper with evidence. It's a felony to fabricate a case against somebody. It's a misdemeanor to mishandle evidence. Why would they do these things? I had to ask myself this question. Why would they do these things? I'm gonna tell you why
It's
they
the
did these
same
things.
reason.
I'm
Yeah,
gonna tell.
it's the
I'm gonna
same.
tell you.
Yeah,
I'm
you
gonna tell.
say.
Well, I'm gonna tell you why. I fucked up because after my arrest, I knew that the officer fucked up on the whole investigation. I knew he arrested me unlawfully. I knew he didn't have probable cause.
Well,
And I
bro, look,
knew,
it's just so crazy too because you look beforehand, homeboy's watching it, playback,
yeah.
playback, playback,
So he
and then
wants to
come
play.
back, yeah,
Hold
and
on,
then come back and delete it.
hold on, Cam. Go down to the very bottom. Around 3-2, Flores watches it.
3-2.
Yeah, at the very bottom.
Oh, to the very bottom.
Yeah, up a little bit. So the first time Flores accesses it, what date is it? 3-3.
No, because
3-3, right there. Go up one, right there. 3-3. Flores access it. Playback.
yeah, but that would be after apparently a purge then.
Yeah, it was after a purge allegedly. But also, why is that important? Because his arrest report was dated 3-2, but his sergeant signed it 3-9.
Yeah, because this is the same file storage number too.
Yeah. So his arrest report was dated 3-2 before this playback. But again, he didn't sign it under penalty of perjury that it was filled out that day. But
It's removed from local storage and he plays it back from the cloud storage, from the cloud.
Yeah.
But then also too. Nope, that's a
So
upload.
let me give you guys a little context. After the arrest, he was getting a warrant. I made him get a warrant because they didn't consent to the blood draw. They said, we're going to have to suspend your license if you don't consent. I said, I don't give a fuck. Get your warrant. And after the arrest, I became pissy. That's when I became insulting. That's when I became a jerk. I was visibly pissed. I was a jerk. I ain't gonna lie. I was an asshole at that point. I was calling him names. I was telling him he's a scumbag. I was doing some mean shit, right? I was pissed. I was like, dude, I'm fucking gonna spend the night in jail because your dumbass don't know how to do your job. And now I gotta fight this shit in court because your dumbass don't know how to do your job. And I said, when you get the blood results and they come back 0, I'm fucking suing every single one of you. That's where I fucked up, guys. I said that the night of the arrest, and it was on camera. I said,
What's wrong? What's wrong with saying that?
Because the second I said that, you know what they said? They got the evidence. I can tell you. Go to the chain of custody logs, Cam, again, and you'll notice everything happens in those first few days. That I said that I was going to sue them the night of the arrest.
Yeah. What? I'm sorry.
What's wrong with that?
Well, it puts them on alert and they go into retaliation mode.
Anything that you say or do can be used against you, not necessarily in that court.
Yes.
So, that's why the smartest thing to do is shut the fuck up. Your mouth shut.
Yes.
Yep.
100%, guys. You just shut the fuck up. Don't say nothing. Invoke your rights, stand on your rights, and remain silent. At that time, I let my emotions get to me. I was pissed. And I was fucking being a jerk. And they used everything against me in court. Every insult that I threw at that cop, they showed the jury. And that's why the jury convicted me. They're like, oh, this guy's a fucking asshole. The jury didn't see any of the detainment where the cop lied, where the cop did things he wasn't supposed to do. And you guys got to remember that I was assigned a public defender. I was held in contempt, signed a conflict attorney. And my conflict attorney never did anything with me, bro. He didn't go over my case at all. The matter of fact, the clerk's transcript on appeal shows that he didn't even submit any written motions on my behalf. He submitted oral motions and lamines that were denied by the judge, but there's no written record of what he did for me. When I have emails of me asking him to investigate the spoliation allegations, and I asked him to suppress the warrant and how he would do it. He stopped responding to me completely. He never responded to me again throughout trial through conviction. Not one single email response for 5-6 months. 5-6 months. That's ineffective assistance to counsel. I'll be arguing that on appeal. But guys, let me tell you something. Why would counsel go silent the second I ask him to investigate the spoliation and suppress the warrant? Why would he go silent? Because
one thing I want to ask too is like when they went ahead and forced counsel upon you, did you take it up to the DCA?
What do you mean DCA?
Like, did you try to get that attorney up off you and go up to the District Court of Appeals to?
Yes.
And then what? Okay, so you did attempt to get your
counsel off. Yeah. And that was his statement. He stated that because I sent him a cease and desist notice, said, you don't represent me. There's no contractual nexus between us. I don't consent. The court doesn't have the authority to revoke my rights. If the court's asserting it does, it needs to prove it. And The contempt order is dog shit. It's null and void. I'm
Because Brian had to do that.
yeah.
Brian, are you listening? You want to unmute real quick or no? I know he's in here, but I don't know if he's available to talk. But yeah, like we had to go all the way up to the DCA to get.
Hey. Yeah.
Yeah, go ahead.
So
So did it
what
work?
is it?
You
Yeah,
had
so
counsels.
so the first time when I first went to the hearing, I told him, I said, like, I'm gonna represent myself, which is back. I mean, I didn't know nothing about nothing, right? So they just didn't, they didn't hear me. So then I filed for a Feretta hearing. The judge in person, the first judge, she had a choice set of words. I don't remember exactly what they were verbatim, but she was basically making me sound like an ass clown and that I wasn't smart enough to compete with them. But it was her choice of words. So got a transcript and then filed some. I don't remember exactly the title of it, but we filed something with the DCA. So the same judge basically said, if they're going to tell you you're not smart enough, had to sign off on her own disqualification, and we moved on to the second judge. But
Yeah.
it took about 3 or 4 times. I mean, even the second judge had another Feretta hearing, and she want to sit up there and act like somebody can't, don't have the mental capacity to compete
And
with
this
them.
just
And then,
wasn't and this just wasn't orally either. Like homie was like, "Hey, like I'm requesting again for my Feretta hearing," and she just denied him off of
Yeah.
some BS, and that's the kind of thing is that like even though they deny you a few times on the lower side, he still took it up and was like, "Listen, she ain't doing her job." And once she got threatened with that, then she changed it up. It
Yeah.
was like she just went ahead and recused herself. Then she's like, I guess I ain't got no power to keep doing this. And that's
Yeah.
what I'm saying. Sometimes you got to hit for them writs, bro.
Yeah. So I did, guys. So I did file some writs. I filed a writ of habeas. First, I filed a writ of certiorari, and then I realized that they summarily denied that. And then I realized, oh, habeas corpus is the appropriate writ for a direct contempt order. So then I filed a writ of habeas corpus with mandamus because I was also asking for them to give me the transcripts and to also provide me the written ruling on my suppression motion. And the Court of Appeals denied that request. In the order, it says the petition was construed as a writ of mandate, and as construed was denied. So that tells me you didn't give any consideration. You didn't give me any expressed consideration of habeas corpus. So then I filed another writ of just habeas corpus. I removed the mandamus request, removed that material, and I requested a petition for habeas corpus, and they denied that as repetitive.
They was wanting the mandamus. That's why.
They would. So they denied the joint petition first as one for mandamus. They construed it as one for mandamus. They didn't give any expressed consideration to habeas corpus.
No.
Now they can try and say, oh, they can try and say
but
we considered it, but they
well,
didn't give any
yeah,
expressed. They didn't give
yeah.
any expressed consideration.
Well, that's
So
because of course, wait, yeah, of course, because at that point, the mandamus would have been structured different, right?
yeah,
The formatting of the mandamus would have been different, and they're essentially just pointing out that hey, we're going to construe this as you're wanting us to do this, but you didn't bring it in the format of a mandamus,
yes,
right? You're in the format of habeas corpus, which is a total different format in which we actually see and view things.
yeah,
So, it should have been this way, but it wasn't that way. So I guess that's the only thing, utilizing habeas corpus where it's needed versus
yeah,
your mandamus in and of itself. So
yeah,
just quick clarification on that one.
yeah.
Okay.
And so then I filed just a petition for habeas corpus, and then they said it was repetitive. But it's like, how can it be repetitive if you've never given me express consideration? How can it be repetitive if you've never adjudicated on the merits?
Well, I guess what they saying in that one too is I'm just taking it off the cuff, would be like, listen, bro, you need to be bringing us a mandamus,
No,
even though they're not expressly saying it.
no, Cam, a mandamus does not. You're looking in two different postures. I was
The
held in.
mandamus would have told them to do what the duty that they're supposed to do, right?
I know, brother, but I was held in direct contempt, and the direct contempt order is what revoked my pro per rights. Do you see what I'm saying now? They granted me my Feretta motion in the beginning.
That's
So
right.
they granted me my Feretta motion in the beginning, and I was representing myself. Then they held me in direct contempt, and the judge in that direct contempt revoked my pro per rights, and then assigned me counsel. So I have to get rid of that direct contempt order. I can't file a Feretta motion. A Feretta motion is not the remedy for having your rights revoked. It wasn't that they assigned me counsel and I had to ask to go pro per. No, I did that and they granted that in the very beginning. What happened was I started to expose the misconduct and they said, "Oh shit, shut them up." revoke his pro per rights, throw him in jail. I give him counsel, and then the counsel is on our time. He's on our team. We assigned the counsel. We're gonna tell the counsel, hey, you better make him do this. Make him shut up. Make him take, do this. Don't expose the misconduct. He can't create a record. He can't have an evidentiary hearing to create a record that exposes all the bullshit we've done. And that's what happened to me. So in order for me to get the direct contempt order revoked, if you guys are ever held in direct contempt, the only remedy is habeas corpus. The mandamus is not the remedy. The only remedy for a direct contempt order is habeas corpus, a writ of habeas corpus. And so, that's why.
I mean, how did that work?
No. So after that judge yelled at me, you guys heard that earlier. He yelled at me. That was on the 14th. Then he goes to recess. I should have never went back in that court. If I never went back in the court, I'm a firm believer that I would have had the case dismissed because he abandoned his duties, and I claimed the right, my equitable right, to dismiss the action for lack of prosecution, right, and lack of state diligence. But I didn't. My dumbass went back into the courtroom. So when I went back into the courtroom, the judge said, hey, I'm going to give you a couple more minutes to talk, and then we got to move this thing along. And I said, he's like, do you understand? I said, well, no, not really. But in part, I need to get my stuff on the record. And then he interrupted me again, rushed a ruling, said motions denied, and ran off the bench again. When I was one of his first calls for the docket, he had a full docket and a full room of people. He ran off the bench again. Why would you do that, bro? Why wouldn't you just make your ruling and move me along and get to the rest of your docket? Why do you keep fucking running off the bench? You know what I'm saying?
You can't give them more stuff for you to have. And by the way, removing, and removing your right. It's all a big club, and they all serve the same master.
Yes.
That's why it's want.
Yes.
It's
Exactly.
want only. But your pro per, they removed your pro persona.
Yes. You're whoever you are. You're following along, Danny. Yes. So that happened, and when he rushed the ruling, he told me you need to be back in 3 days, on July 17th, for trial, and you better be ready for trial. We're sending this to trial. And I said, I said, well, I object to that. I need more time. He said, well, then you didn't file a motion to continue. You didn't do this, that, and the third. Blah 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 blah.
Stat.
So
well, hold on, Danny. You keep breaking up. That's why he cutting you off, because you breaking up, Danny. Just so you know what's going down over there on your side.
My mic is off.
Oh, yeah. Well, I thought it sounded like he was breaking up, bro. My bad.
Yeah. So so within that, the 14th and the 16th, which is when I filed my documents, I was just like panicking, bro. I was like, I can't believe what's happening, dude. They're trying to send this to trial, and I couldn't even create an appellate record. I couldn't suppress the warrant. I don't have a probable cause determination. I don't even understand what probable cause is. The evidence is incomplete. They don't give a fuck about that. I'm like, okay, Mike, what's the play? What's the play? Well, I filed an objection to the actions. I stated what the judge said in the hearing to the best of my recollection. And those pleadings I'm not proud of. They're dog shit. They're like rushed. I never revised. I didn't spend time on it. I mean, I did all this stuff within maybe 3 hours. But I filed the objection, and then I said, Mike, you know that they tampered with the evidence, bro. Ask for a stay and request an evidentiary hearing. They can't send you to trial if you're claiming that the evidence is tampered with. Surely they couldn't do that. So I requested a stay, and I requested an evidentiary hearing to address spoliation concerns. And then I listed a table of 16 flickers and anomalies within the video recording that I wanted to address, amongst other things. I left it open-ended. I didn't want to tell you exactly what I know, right? And I filed that on the 16th, the day before the trial date was set, right? So I filed that the 16th at 3 p.m. They didn't really have time to review it until the morning of. So then we go back to court on the 17th, and the judge tells me, you filed some documents. I need time to review them, so go ahead and take a seat. We'll get to you later. So I took a seat, and he gets to me later. And then when he gets to me later, immediately he gives me a warning that, on the 14th, you had a couple incidents where I had to warn you to be respectful of the court and da 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 da. And I gave you a warning that, I don't want to hold you in direct contempt, but you got to follow the rules of the court. And when it's my turn to speak, it's my turn to speak. Like immediately, unprompted. I didn't say anything. I didn't do anything wrong. And so I'm like, okay, like this guy's setting up the record that he has had issues with me so that he can hold me in contempt. And sure enough, he held me in direct contempt. I mean, the reason he held me in direct contempt was I was asking for clarification. And it's in the transcripts. I said, hold on there. Are you stating that that's on the record? because he said he read my documents. And I'm like, well, if you read my documents, then you need to recuse yourself. That was where I was going to go. But he never said on the record. You know, he said he kept repeating, I read the documents. But I'm like, Judge, can you say that on the record that you read the documents? And he's like, that's warning one. I said, no, it's not. I'm asking for clarification. He's like, that's warning two. I'm like, Judge, I'm just asking for clarification. He said, that's warning three. And then I stopped. I'm like, I don't understand what you want me to do here. He said, and then something else happened. And then I asked another question. He held me in contempt. That's how the contempt issue happened. And it's in the transcript. So, like, I mean, it couldn't have been more clear that this judge had said that he read the documents. He realized the impact. He said, oh, shit, he's on to us. We can't let him have an evidentiary hearing to expose this. This is just my presumptions, guys. All right, I'm just making assumptions here. You know, it's my little conspiracy theory that I've drafted in my head based on my experience with it. And I'm just assuming. I'm assuming he said we don't want him to expose. We can't. I don't know what he knows because he didn't disclose it all. But what I'm gonna do is I'm gonna hold him in contempt and sign him an attorney, and then we'll get that attorney to do our will. You know, because we're all in on it, and if we're all in on it, it's super hard to prove conspiracy, especially if the entire system's in on it. Nobody can crumble. If nobody crumbles, then it's much harder to prove because it's like, hey, we were just doing what we thought was right at the time. Just because it happens to align with, you know, some kind of inquiries or suspicion doesn't mean anything, right? You can't prove that, right? So he held me in contempt, threw me in jail, signed me the attorney. The attorney, as soon as I asked to investigate, he stopped. He was communicating with me effectively for 3 months. And I was in the appellate process, like Cam said. I was trying to file my writ of petitions of habeas corpus to get my pro per rights back. And the Court of Appeals kept denying me, guys. So I was like, damn, even the Court of Appeals have been informed, like, oh shit, we're in trouble. The lower court needs, you know, I'm assuming the lower court's like, yo, we're in trouble. We need you to, like, you know, don't give this guy relief. Find some kind of procedural barrier to deny him. This is the only thing I could think of. Because if you guys seen the contempt order, it's dog shit. It looks like a first year law student drafted it, and the judge drafted it. It's really bad. It's basically just a bunch of assertions that I did something. No evidentiary reference, no record, no transcript inserts, no quoted language. Any quoted language was what he said. And it's like, okay, just because a judge uses triggering language, right, during a hearing doesn't necessarily mean that those events happen. He said triggering language. He knows what certain language courts identify as a triggering word that indicates, like, for instance, the court was paralyzed is one of the things he stated. Paralyzed from conducting proceedings through the interruptions. The defendant failed to follow lawful orders. Those were the assertions made in the contempt order, guys. What order did I fail to follow?
Yeah, that's appealable.
What? Oh, 100%. What was it? A written order? Was it an oral order? What was the exact order that you gave me verbatim?
Yeah.
And then how did I violate it? Did I do it willfully? Did I say fuck you and your order? You know, did I say, Judge, I'm not going to follow that order. I'll do what I want? Like, what was said, guys? If the contempt order is 2 pages, double space, it's dog shit. There's no particularized facts that a contempt actually occurred, which is required for a direct contempt. Matter of fact, it's jurisdictional, right? Under N. Ray Littlefield, it's a California case. The requirement to restate the facts with clear particularity and specificity without reliance on excluded or extrinsic documents, right? Documents outside of that contempt order. Because a direct contempt order is, since the punishment is immediate, the adjudication must be immediate. Does that make sense, guys? If you're going to punish immediately, if you're going to summarily punish, then your adjudication must also be filed immediately. It has to fall a line. You can't file your punishment after a couple days of reviewing transcripts, right?
This one's one of the better ones that you included. Looks like in this writ of mandate, just for everybody's awareness. It says where the pattern of unexplained destruction, retroactive alteration, and constructive denial documented herein injures or inures exclusively to the benefit of the withholding party, that pattern gives rise to cognizable inference of consciousness of wrongdoing sufficient to compel an immediate judicial intervention, right?
Yep.
So that one's really good too because, yeah, that's a strong support right there, my boy.
Yep.
So, Michael, what are you going to do next time you get charged with a contempt charge at court?
It won't happen. It won't happen.
What are you gonna do though immediately if you do?
So it's my understanding that I would ask the judge, I would say respectfully, Judge, what contract or other commercial agreement did I sign knowingly and willingly that obligates me to the court's instructions? And can the court identify specifically if my actions differ from legal advocate for my defense or actual contempt? Can you identify and express to me how you've determined that before I plead? Remember, contempt's a complete new jurisdiction. Right. So now it's like, by the way, Judge, what jurisdiction are you charging me in? First of all, can you tell me the nature and cause of this proceeding? Now that we are in contempt proceedings, can you tell me the nature and cause of this proceeding pursuant to the Sixth Amendment? Is this a criminal or civil contempt, Judge? And if the judge tells me it's a criminal contempt, well, fantastic. Let the record reflect the judge has identified a criminal jurisdiction. Now, Judge, the Constitution grants us two criminal jurisdictions. One is under common law and one is under admiralty or maritime contract law. Can you identify which one of those jurisdictions that this contempt order is being held in? And then the judge won't answer. And if the judge, and then I'll ask, well, Judge, is there an injured party? Well, no, there's no injured party. Okay, well, then it cannot be a jurisdiction of common law. So, Judge, I can only presume that we are in admiralty maritime law jurisdiction, criminal jurisdiction, under Article 1, Clause 8, Section 17 of the Constitution. And if that is the case, Judge, then can you please identify the contract or other commercial agreement that obligates me to this court's instruction? And if you cannot produce that, Judge, then I cannot effectively enter a plea. I cannot knowingly enter into any contract, Judge.
Or intelligently, because you got to hit on the other side too. Like,
yeah,
you got to say intelligently, because if you coming in with the intelligent side, like, I like to think of it like this. If we're going on this route, of course, anyways, but the intelligent part of it leads into, I don't know what the state, it's a like plea relief, right? So all your objections before plea, and intelligently ties into, I don't know what all the state got against me. You see what I'm saying? Like, the state could have a whole bunch of evidence that makes me look horrible. So maybe my intelligent plea would be to go ahead and plead guilty here.
Yeah.
Right?
Yeah.
So before even we get to that point, I need to have the evidence that the state's got.
Yeah.
Because you asking me to intelligently make a plea now.
Yeah.
You see what I'm saying? So it's deep.
And mind you guys, for direct contempt, it occurs right then and there. I mean, he gave me probably 45 minutes to talk to the attorney that he assigned me, but I spent that entire 45 minutes telling that attorney to basically fuck off respectfully, you know? And I told that attorney, I said, look, if he assigns you to me, then what I need you to do is this. I need you to do this, this, and this, and this, right? I'm not here to argue with the court. I'm just here to create my record. I just need to create my record. I need to be able to identify the warrant before the court. I need to move it before the court. I need to be able to challenge the warrant to the prosecution and have them identify probable cause for me. Because this is the only document that matters. This warrant is the only contemporaneous affidavit that was signed by the law enforcement officer the night of the arrest. Anything that stated that
I don't even think he signed it from what I looked at. I think it was just Superior that signed it.
The warrant, I think he did sign.
That may have been the only thing. He didn't swear on the I know I didn't see anything sworn on the affidavit.
Yeah, that
police report.
The police report, he did not swear.
No,
it's not a sworn police report.
No, that was not a sworn statement at all.
Yeah. So yeah, that's what I was trying to tell her. And basically what happened is she's like, oh, well, you know, she started saying a bunch of bullshit. And she's like, well, oh, maybe that's not the real warrant. Maybe that's, you know, maybe they have the actual warrant in their possession. I'm like, what the fuck are you saying, bro?
What do you mean real warrant?
Yeah, it's not the real warrant. This is a temporary warrant to get to the real warrant. Then are they withholding exculpatory information from me? Are they withholding evidence? Well, however you're spinning this, lady, it's not making sense. I don't think you're competent enough to represent me. I'm like, and I had a witness with me, by the way. My buddy was with me right there having this for the whole conversation, and I recorded it. I was like, I don't think you're competent to represent me. If that is the legal advice that you want to give me, I said, look, what we need to do is we need to go in there. And I need to do this on the record, please, so that my record has what I needed to have for the appellate review. And she's like, well, I'm just here to help you. I'm just here to help you, blah, blah, blah. And then we go back into court and she entered a plea of not guilty for me. And we never talked about entering a plea. Well, guys, that's fraud of inducement.
Was
That's
that a
fraud of
felony
inducement.
about the
Right.
warrant?
Yeah.
That's fraud of inducement.
For my
It
bro.
was it a capital or infamous crime? Because if that's so, if they call it a capital or infamous crime, a grand jury has to produce that warrant. So that's another way.
No, it wasn't a capital infamous crime.
Uh,
But she went and she entered a non-guilty plea on my behalf, which gave the court jurisdiction, guys. So that's why that was my issues, because anytime I tried to ask about jurisdiction, the judge told me we're not talking about jurisdiction. He tried to get me off that topic because he needs me to enter a plea before he can punish me. Because the second I enter a plea, you guys know how this works in Admiralty Maritime Law. The second you enter a plea, you've now consented to the court's jurisdiction. You've waived personal jurisdiction and you fucked yourself, right? Now, she entered a plea on my behalf without ever discussing a plea. So I've got videos of this shit. So one day when we're done with everything, I'm going after everybody, bro. I'm lost. That's fraud of inducement. And I have a record on file with the court. In my original motion to dismiss, I attached my testimonial affidavit, a written testimonial affidavit. And in that affidavit, I stated very clearly that I now and forevermore challenge the jurisdiction of this court, personal, subject matter, and subject jurisdiction. That's on the record, which means when we went to that contempt hearing, that was my testimony. That was my challenge to the jurisdiction of the court. And I also have in that testimony, I need to know the nature and cause of the proceedings. So I have a written record of me requesting those things. And then they pushed me into a contempt order like months later, a contempt proceeding months later, and never provided me with any of that information. Matter of fact, they revoked my proper rights summarily. No contempt order existed yet. He just, no order exists whatsoever of him revoking my proper rights. He just said, yeah, you don't have your right to represent yourself. You're going to have an attorney when you come back to this hearing. The same day, bro. Same day. Because I said, I need to go do something for my daughter. I didn't know this was going to take this long, and I need to go pick my daughter up from the doctor's appointment. And so he granted me leave to do that. And then I had to come back at 2:00. And that's when he assigned me that counsel. He said, when you come back, you're going to have court-appointed counsel. I said, no, I'm not. And I came back, and sure enough, she was right there waiting for me. And then we talked, and I said, please, fuck off, like respectfully. I didn't tell her to fuck off. I said, please, I don't want you to represent me. Can you please leave me alone? I don't want to talk to you. I've got to get my record straight and clean. And that's when all the rest stuff happened, right? So it was, guys, in one day, this dude basically granted me leave to go handle my family matter. And the second I came back, my pro per rights are gone without an order, no judicial order. No judicial order revoking my proper rights. And then he holds a contempt proceeding with that alleged counsel over me, right? With no order, no contract, no legal nexus, against my objections. She enters a plea on my behalf. And then he ends up entering his contempt charges and finding me in contempt and issuing a contempt order. Do you guys realize what I'm telling you right now? That is the definition of fraud, of inducement. Unlawful representation by the state. If there's no judicial order revoking my proper rights, she had no legal nexus or contractual agreement, no authority to do what she did. And the state didn't grant her the authority lawfully or legally because there was no judicial order doing so. The court cannot just verbally say, you don't have your proper rights, she's representing you. You guys understand that, right?
Yeah.
They can't do that. But that's what they did to me. And it was all within minutes, guys. It all happened so fast. And I'm just like, I'm responding in my mind like, what the fuck are they doing? They can't do any of this shit. And then he held me in contempt, threw me in jail right away. So
and that was because you're denying counsel?
No, he threw me in jail because allegedly he allegedly revoked my pro per rights and signed me counsel because I was allegedly interrupting the court when I was asking for clarification. Because I was asking him to clarify if he read my documents that I just submitted the day before. Because in the beginning, in the morning time, I went to court. He said, I need time to review these. I've got a docket to get through. Maybe you can just sit tight, right? I'll get to you before lunch, right? And so he gets through his docket, and it's about 11:30, and I'm hanging out. It's about 11:30. He calls me, and he says, hey, so, I've reviewed the record a little bit. But you know, there's a bunch of stuff that doesn't make sense to me, and da 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 da. And then I was like, well, Judge, with respect, before we get to that, can I go pick up my daughter and come back and we finish this at 2? And he said yes.
I think I deserve the same kind of respect back. No, you're about to interrupt me again, so please stop. It's simple rules. Now, over 18 years,
I'm just like, bro.
I've never held anybody in contempt and ordered them remanded. I don't intend to start today, but you need to follow the rules. It's not that complicated. So if you have anything else you want to add that you haven't already told me or haven't already put in your statement, I'm happy to give you a couple more minutes to do that. Does that sound fair?
In part.
Well, that's what I'm going to allow you right now.
Okay.
Because you've yet to provide me any legal cause or anything that even resembles a cognizant, discernible legal argument. But I'll give you another couple minutes to do so, and please proceed. But you need to follow along when I say that I've heard enough, and when it's my turn to rule, and when Ms. Massey has a chance to respond, you have to give us that respect. Okay, so number 1. Go ahead, sir.
So with respect, I started off by saying, please allow me to finish without interrupting. So you interrupted me first with respect, and it's on the record. I will continue.
2 minutes.
If you need me to continue, well, I have a right to be heard in a meaningful way.
No, within reason. I don't have to control my courtroom.
Understandable.
You have 2 minutes.
So
tell me whatever you have to say.
So then we are going to stipulate to what is in that document. It's on the record. So we'll stipulate to the rest. I'll skip over it. I'll continue. The burden of proof to prove jurisdiction falls on the prosecution, once challenged properly, to ensure proper process and the law was adhered to in obtaining evidence and making a complaint or making a claim or complaint against an individual upon arrest. That's what I'm challenging today.
Is this the one where he found you in contempt?
No.
Oh, okay. I thought this was the one because right there he's threatening.
Definitely not, Cam. Definitely
Yeah.
not this one.
So that's what I'm saying. He was setting it up from the beginning, bro. He was setting contempt up from the beginning. He was exaggerating, making it seem like I was interrupting him, and yada. He was exaggerating the shit. You know what I'm saying? And y'all just seen he was talking. He said, "You're about to interrupt me again." I'm just like shaking my head, like, bro, I can't respond to something you say.
Oh, this one's a long one though.
This is on the 17th, right?
Yeah.
This might be the one where he holds me in contempt.
It'll say
Yeah, this is the conversation I had with the attorney.
He was 5.07. He was fine. That happens at trial.
She kept telling me shit happens at trial. I'm like, no. We need to establish jurisdiction before trial.
And it was far less than 3. I'm not going to say the numbers. I'm not going to say the number. But I know, because I was his DD. I was his DD. I was his DD.
Very strongly adamant that, Americans have a true right.
Yeah, this is all beforehand.
No, that was it. That was my testimony for the contempt trial. At the end of it,
Mr. Carey's testimony did nothing but actually.
Yep, right here is where he calls me in contempt.
About the name, which is to find him in contempt. His defense is judge was to attack the court, disparage the integrity and dignity of this court. I call it
Conflict right there.
Conduct of accusing the court of violating process rights. To the contrary, the court had gone bent over backwards to protect his due process rights. Even this morning, when I tried to, I told him I wanted to go through point by point everything that he filed and what he included today, which I think is untimely, but nonetheless, he deserves to be heard on it. He cut me off, interrupted me, chaos, could not proceed in a meaningful manner. I also take some implication that I don't respect rights.
I knew it was coming. I knew the contempt was coming, so I was getting my phone ready to turn it off.
Take your rights very seriously, as I do everybody's. The court will find that the defendant is in contempt of court under Code of Civil Procedure 120981, disorderly conduct towards the court, which tends to interrupt the proceedings and disrupt the proceedings, and Code of Civil Procedure 120985, Court this time has been sentenced to the defendant to 2 days in county jail for forthwith. Hold on just a second, gentlemen, before we remand them. That will be served forthwith. I have to consider whether a stay would be appropriate. I think it would not be appropriate because of the need for Mr. Carey to understand the seriousness of his conduct and that he does not run the proceedings and that the respect of this court, any court that comes before, needs to be followed.
So he put you in jail for 2 days?
Yes, right then and there.
That's crazy.
Right then and there. You guys.
My thought is this, Ms. Thompson and Ms. Johnson, if you want to pick another date for trial down the road, I think that might be a good idea.
I would suggest 2 months from now.
Yes.
About 2 months from now, and he prefers a Tuesday.
So we suggest maybe September 9th or 16th?
It's up to the court. I'll advise you.
So they put you in 2 days jail right then and there?
Right then and there, bro. And I had my daughter that, she wasn't with me. I dropped her off with a friend, but like single dad, she didn't even know I was going to jail. Shit, I didn't know I was going to jail. But as soon as he started talking towards the end, you hear a bunch of like scattering. That's me getting my paperwork all together, right? Because I had a bunch of paperwork and a whole bunch of stuff that I was trying to present. I was getting it all ready because I seen it coming. I was like, oh, I see what's going on. I know what's going on. He's gonna throw me in jail. So I started getting my paperwork together and I tried to hide my phone because I wanted to be able to turn off the recording before they arrested me. So it got uploaded to my cloud. Because I was like, I need to make sure that I fucking keep this recording and they don't delete it and they don't see that I was recording and they don't catch me and they don't make me delete it. You know what I'm saying? So I was trying to hide my phone. I was trying to get my finger near the button and like play it off. So I ended up stopping the video. And then right after I stopped the video, I grabbed my folder and I pulled it into me. And that's when they arrested me right then and there. They took my folder from me, and I tried to throw my phone to my buddy because I thought he was still behind me. My buddy had just left, like, because he didn't want to see me get arrested, bro. He's like, bro, I ain't gonna lie. He's like, I ain't gonna lie, bro. I'm sorry, I had to leave, but he's like, he was dealing with his own criminal matter too that he had just got in trouble with. He's like, bro, I didn't mean to like just leave on you or anything, but like, I didn't want to see them arrest you, bro. And he's like, this shit is giving me fucking PTSD. He's like, I've just watched you get yelled at on the 14th. I'm watching you get arrested today. I've got my own criminal proceeding in this exact same fucking court. He's like, bro, it's scaring me for my shit. It was fucking me up. He's like, I had to leave. So I didn't know he had left the courtroom. So I threw my phone back to him and I was like trying to talk to him. And then I seen he wasn't there and I was like, wait, what the fuck? And they're arresting me, bro. They won't even let me go pick up my phone. I'm like, yo. And then the court appointed attorney picked up my phone. She's like, do you want me to hold on to this? I was like, no, it goes with me. Like, I don't know who you are. You're not keeping any of my stuff.
Okay, so
all
let
my
me
stuff goes with me.
so let me ask you this then. What would you have possibly had changed to have yourself not be held in contempt?
If I could go back in time, I would have been more privy to the game. You know what I'm saying? At the time that it was all happening, I knew the judge was on bullshit, but I didn't know how to respond. So guys, I'm going to teach you something right now that is really, really, really important. The court and the judge and the prosecutor, they can only deal with conflict. The prosecutor wants to create the conflict. The judge is supposed to handle conflict, right? So anytime you go to court for any case, if it's a traffic infraction, no matter, the second you plea, guess what? In legal theory, you just created the conflict by pleading, even if you pled not guilty. You created the conflict that the court needs to establish jurisdiction, right? And then you start arguing and making filings, and there's a reason, and the legal process is necessary in most cases. But learning everything that I've learned throughout this is your job is to not create conflict where you don't need to. You know, your job is because the second you start arguing and litigating, if you do it the wrong way, the burden has shifted to you somehow, even though you're supposed to be innocent until proven guilty. You want to keep the burden on the prosecution as much as possible. You want to hold them responsible for proving their case. And then just like Ken was doing when he was going through their stuff, he's like, oh, I would have been on their ass. That's your job. Your job is to attack their paperwork and find the discrepancies and then present that to the court in a non-argumentative way. So what I would have done is I would have requested an evidentiary more properly, much further ahead of time.
I would have gone back and filed a request to oppose their opposition. I would have requested a continuance of the evidentiary hearing that I did have, and I would have said, "Yo, Judge, I received their opposition through email Friday night, just 5 days ago, and I haven't had a chance to review it. Can you please grant me an extension of time so I can respond effectively?" I would have done that before even having the evidentiary hearing. And then and I would have filed that immediately upon receiving their email on Tuesday before we got to the evidentiary hearing. And then as for the 14th and the 15th, I would have handled the judge in a much different way. I would have been more patient. Now, the reason he got pissy is because I spent 10 minutes basically setting the court up and creating my record to sue the DA for malicious prosecution. I was basically reading my record on my document that in my document I told them, DA, if you continue to prosecute me, knowing that you do not have probable cause and knowing that the warrant that you rely on does not meet any of these legal standards, right? Identified U.S. versus Hotel, State versus Pollock, Mincy versus Arizona, all these things, and that the warrant does not meet any of these federally required um, mandates,
Elements.
elements for a Fourth Amendment claim or a Fourth Amendment seizure, then I will prosecute and sanction you to the fullest extent of the law for malicious prosecution. I had put that in my paperwork early because I wanted them to dismiss the case, and I wanted to also give them notice because you got to remember, part of malicious prosecution, the hardest thing to prove is they prosecuted you maliciously, right? And that's the most difficult element. So if you don't give them notice that they are doing so in writing, then you don't have that element, and you'll never get that element because they're just doing their job. But if you tell them in writing, like, hey, if you don't have probable cause, and not only do you not have probable cause, but the warrant that you rely on, the charging instruments that you're relying on, do not meet the Fourth Amendment federal standard. It doesn't meet any of the elements required for a Fourth Amendment federal standard. So please stop prosecuting me, or else you're doing it maliciously, and it's not right. Right? You have to give them notice that what they're doing could be malicious, and you got to tell them, "Hey, I've reviewed your claim, and it's malicious. There's no basis here. There's no standing." So I did that early in my paperwork, and they just kind of ignored that shit, right? So I spent 10 minutes reading that paperwork and putting that on the record. And as soon as I read that part where it says, if you continue to prosecute me knowing you don't have probable cause and the warrant does not meet these standards, then I will prosecute and sanction you to the fullest extent of the law for malicious prosecution. As soon as I said that, that's when the judge interrupted me. And that's when the judge started to do his thing. Because the attorney, she looked frozen. Her face was turning white. She was just quiet. And she was just looking at the judge like, save me, help me. And then that's when the judge started interrupting. That's when everything happened. So knowing how they do that, and knowing that the judge was having her back in that moment to prevent a record for malicious prosecution and how everything goes, I would have spent a little less time on reading all of it into the record. I would have spent a little more. I would have been much quicker to get to the actual point, because you have to efficiently argue your point. If you're going to litigate it in open court, you have to get to it timely, and you have to lay the foundation effectively. And I spent too much time laying the foundation that I never got to get to the merits of my argument. Now, that is an appealable issue because I have the transcripts, and the transcripts prove that I never got to get to the merits portion of my argument, my oral argument, because the judge interrupted me. So it is an appealable issue, but that's what I would have done differently to avoid the contempt. Is I would have set less time setting them up for that, and I would have gotten to my point quicker. And then when the judge started interfering, I would have reminded myself, he's not the enemy, Mike. I know what he's doing is fucked, and he's helping the prosecution, but he's not the enemy. Be respectful, request, Your Honor, do I have a right to be heard? May I be heard now? Are you done? May I be heard? And then I would have reminded myself that I cannot answer his questions effectively if I don't get what I needed to say, because they're going to obfuscate you guys. They're going to interrupt you. They're going to try and get you to have your brain taken off subject. They're going to try and get you to respond to their questions. And in this legal system that we have, the person who asks questions and gets a response is the person of authority. So if you allow the judge to ask you questions, you're constantly responding to his questions, you're literally granting him the authority he needs to do whatever he wants to do. But if you reflect that and you answer his questions with your own questions that are more articulate, which is hard to do, but you got to know the system. You got to know your case. It's my hearing. This is what I came for. Stick to it, right? And if you're able to do that and you're able to ask the court certain questions, he can't say you basically. What I would have done is I would have turned my statements into questions towards the court so that he can't say that I'm interrupting the court, and then I'm making him answer my questions so that I'm basically getting what I want on the record in a crafty way by asking.
In a court cognizable way.
Yes, in a court cognitive way where I'm asking the court the proper questions that he has to answer in order to establish and build my record, if that makes sense. And I would have prepped for that the day before, and had a script. It's important to always have a script. Now, I had a script that day and I followed my script, and my script was effective, but I couldn't, because in my script in the very beginning, I said, with respect to the court, I asked the court honor my right to be heard in a meaningful way. And in order to do that, please do not interrupt me while I'm presenting my case. If you have questions, please hold on to them until I am finished. And I give the court my good faith assertion that I have done my diligent effort to make it brief, to make my matter brief. But I do need to state what I need to state on the record. I had said that in the beginning, and it still didn't matter. He still interrupted me, and that's why in the video you guys see me object, and I said, Judge, you interrupted me. For the record, you guys didn't see that part of the video, but in the very beginning, I had said that. So it's like I knew that the judge was going to interrupt me. I accounted for it. I asked him not to do it, and he did it anyways. So, and then when he did it, I didn't respond properly. Now, did what I do, was it a contempt of court? No, I don't think so. I think it was legal advocacy, and that's what I will be arguing in federal court. Which is the posture I'm in, because I filed my petition for habeas corpus. Like I told you, they construed the first one as a mandamus. So then I filed a single petition for habeas. They denied it as repetitive. Then I went to the Supreme Court of California and I filed it. California remanded it back down to the Court of Appeals for consideration and said if it's deemed repetitive, then it must be denied as repetitive. So then the Court of Appeals denied it again as repetitive. So then I filed another petition in the Supreme Court of California under original jurisdiction, and the Supreme Court of California summarily denied that petition. So that's my exhaustion route of state remedy. So then I took the matters to federal court days before my trial, and the federal court did not get to my matters in time, and I went to trial with counsel, and he threw my case. And so now I'm in the appellate process. And
now, when you went through the trial, though, like, you had counsel do the trial for you. Like, what did they fail on?
Everything. They failed on everything. He put on a good show. He made some good arguments related to the blood testing process. He questioned the lab technician. He made some good arguments about, like, you've got two devices that function hundreds of thousands of blood samples, and how often do you regulate those devices? He did a bunch of like good cross examination with the blood testing process, and trying to dissuade the jury from believing that process is without error. But that's the only thing he did. That's the only good thing he did was that. And it also was my first time hearing that defense, so I was like, yo, that's a really good fucking defense. But as I review it, it's like that's really just like a copy paste defense that all really good lawyers use on that specific subject matter. But when it came to questioning the officer, he didn't question the officer well at all. He didn't cross-examine the officer. When it came to cross-examining the blood lady, he didn't do a good job. She kept referring to a hypothetical person. He never made her state, hold on, you're talking about a hypothetical person, but we're not talking in a big broad scheme of things. We're talking about Mr. Carey directly. So can you refer to that hypothetical person? Can you put Mr. Carey into that box for the jury? And he didn't do that. And contrary to what some people would say, well, wouldn't that be bad for you? Well, so it could be, but then it at least locks her into her statements that what she's saying was to me directly. And then I can then use that on appeal, right? Because then it's like, okay, now as issues come up, if she committed perjury, it's on the record. But if she's talking about a hypothetical person, she's not committing perjury. You see what I'm saying? So he allowed her to protect herself in that sense. And you got to remember, guys, I'm going under the presumption that they're fucking lying about everything.
And it was only one officer that was.
Is only one officer testified. Yet he had
Why
two
not?
partners there.
Why not the other one?
Exactly. Nobody wanted to, bro. You think any other officers want to get in on this fucking fraud?
It's not about if they want to. They supposed to get subpoenaed.
He didn't do that. I also told my attorney that I had two people in the car with me that were my witnesses. They were on my witness list that I submitted in my case file before I had my pro per rights revoked. I also had every officer at the scene as witnesses on my witness list because I intended to subpoena them. All this is documented. There's a paper trail, bro.
Yeah, you gotta
And
get them.
and when I emailed my attorney and I said, hey, I need you to investigate spoliation and how would you suppress the warrant? Because I think that we can suppress the warrant. That's something that I've read the law on and I'm very clear that that's the law. And so talk to me how we suppress the warrant. He stopped communicating with me fully. And then I emailed him 2 weeks later and I said, hey, just so you know, I have two witnesses. They were with me in the car. They're on the arrest report. They're in my witness exhibit. Let me know when you can get with me so that we can talk to them and get them prepped for trial. He never communicated, bro. And then we went to
Okay.
trial. Did he get my witnesses? No. Did he subpoena any of my the other officers to cross-examine them and get, cross-examine the officers' testimonies and trip them up? No. Did he get any expert witnesses to my defense? No. Guys, when I tell you they threw my case, it's bad.
All right, so then you go through the trial, and then you
Yep.
already have a federal case that you've
Pending.
initiated. Yeah.
Yes.
And then you're doing a direct appeal right now,
Yep.
right?
Yep.
Okay. And so with your direct appeal, you're getting everything that you need to get as far as the record is concerned established
Yeah.
over on that appeal side. What's going
Should
on
I
there?
should we discuss how that stuff works for people that don't know in case they ever run
Yeah,
into
you
it?
should break it
Yeah.
down for sure. Yeah.
Okay, so guys, if you get convicted in trial court, you've got 30 days to file an appeal. If you miss that 30-day deadline, you've waived it. There's no going back. So I filed my appeal. I was convicted on the 25th. I filed my appeal on the 3rd of March. But my attorney did it for me, and I didn't ask him to. But he didn't do it correctly because he needed my signature, and he didn't have my signature. So obviously it was like moot. So when I go to court and I'm like, hey, my attorney said he filed an appeal, can you give me that document? She gave it to me. I looked at it and it's like, it doesn't have my signature. And I'm like, this fucking idiot thinks I'm stupid. Asked me to start my video. I filed the document out myself, right? I filed it out myself and I filed it on my own behalf, right? So appellate jurisdiction is a new jurisdiction. So that contempt order is no longer applicable. I can represent myself on appeal. So I filed out the request for appeal, and then you have to file a request for the record on appeal. Do you want to do it through a clerk's transcript? Do you want the reporter's transcripts? If there were video recordings, do you want to use that? You know what I'm saying? How do you want your appellate record to be produced to you? I chose the reporter's transcripts because I wanted those transcripts of the hearings, right? Because that's where my appellate issues are going to be brought because the paperwork's done. What was said during the hearings? So you filed that. When I did that, I filed it on the 6th of March. They took about, by the way, they got 20 days to give you the record after you do that. They didn't lodge my appeal in the appellate division until like the 12th of March. So like 6 days later. Why? That's improper, right? Then they didn't give me the record on appeal for like 3 months. Why? That's improper. Then the court reporters they requested an extension of time, and their reasoning was that they have other records that need to be produced for other appeals. But every case that they cited was filed after my case was filed, so I should have gotten deference. Improper, very improper. So then but the judge granted it anyways. Then they issued me a notice of estimated costs and fees. And that notice of estimated costs and fees says I was going to have to pay $2,800 to receive the record on appeal. And I had 10 days to pay it, or else my appeal would be dismissed. That's this on the record, guys. Guys, they tried everything they could to prevent this appeal going on. Let me tell you. I got that document and I fucking filed an objection immediately. And I said, objection. If you could see on my notice of appeal, I put that I had representation, I had court appointed counsel at trial. And so the record on appeal should be provided to me at no cost because the state cannot provide me one benefit of court appointed counsel and deny me the benefit of creating me not have to pay for things myself in the appellate division. The state can't do that. If the state's going to provide me one benefit, they have to extend that throughout the whole proceedings, through everything, right? So I filed my objection. I found the rules of the court to apply. I found the laws that applied. I found the citations that applied. All this is in my Discord chat, and Cam can make a separate chat for this group, or I don't know if everybody has access to my Discord chat. I don't really want everybody in Wisedome to have access. I just like preferred members maybe, but it's all in my chat if you guys ever go through it. I filed that objection. Guys, I'm going to tell you this. The court recorder requested an extension of time to file the record. The judge approved it the day they filed it, right? I filed my objection. The judge took 13 days to approve my objection. The judge took 13 days to sustain my objection. She submitted a minute order. Objection sustained. The record will be produced at public expense. That's it. No operative language. She didn't tell she didn't enforce the timelines, right? Because statutorily, the timelines are set and those have to be met. Just like I'm obligated to hit timelines and the statutory dates, so are they. She didn't give no force to that. She didn't honor it. She didn't say you must have the record produced by this time. You must have the record produced by this time. None of that, right? And I'm sorry, that's when the reporter asked the extension of time was after that, after the objection sustained. And then so the judge struck the estimated costs and fees from the record and to zero, and then I was supposed to get the record. Then they asked for the extension of time. The judge, the day of, accepts it and grants them the extension of time. But at this point, you're already like 60 days past your statutory limit. They were already past before even asking extension, they're way past their deadlines. You know what I'm saying? So I filed another objection for that.
Did you end up sending anything to the Court of Appeals on that though?
No, not yet. I'm just building my record, and I'm also like, I all I can do is file an objection. I'll build my record respectfully, and then it'll be an appellate issue when I do my brief, right? And if I go to the Court of Appeals, I did actually go to the Court of Appeals and I tried to file a writ of mandate and they denied it. So either I don't know how to file writs or not like me.
You breaking up, but the court, when you take it to the Court of Appeals, you're filing it's already out of the lower court and you're waiting for them to send you that record. So you file it with the Court of Appeals. I'm in that process, me and my wife.
So let me clarify for you real quick, because I'm in the Superior Court Appellate Division. Okay. So that's the lowest appellate division possible. So Superior Court is where the trial was at. Then the Superior Court also has appellate division. Then there's the Court of Appeals, which is like the next step up after the appellate division.
Oh, I see. Okay, so you got another layer of appeals before you get to the Court of Appeals. Okay.
Yes. Okay. So I'm in the Superior Court Appellate Division. So when they were taking their time to get me the record, I did file a writ of mandate to the Court of Appeals, who's their superior, right? And the Court of Appeals denied it. For me, it's the Court of Appeals, 4th Appellate District, Division 2, in California for Riverside County. So they denied my writ of mandate. Summary denial, no explanation why. So I'm like, okay, the Court of Appeals does not like me, man. And they also know that I'm trying to sue everybody because I've not made it a secret. Because throughout the whole process, I put the judges on notice.
It's in the record.
I put the judges on notice. I filed a notice of commercial liability into my state record before trial after the judge yelled at me. When I filed my demand for stay and evidentiary, I also filed a notice of full commercial liability. And I said, any actor, clerk, judge, attorney that sends this case to trial without an evidentiary hearing accepts this notice of full commercial liability. So it's on the record. So they really don't want me to expose them. You know what I'm saying? Because it's like, I already gave you notice, don't do it. You did it anyways. So now if I am able to factually develop that, yes, everything I said you guys did, you did, and the judges held me in contempt, and then the judge allowed this to go to trial without the evidentiary hearing, even though I requested it. Like, you know what I'm saying? Like they really not fucking with me, bro, because they know I'm gonna sue everybody. And so I tried to get the writ of mandate, it got denied. I said, fuck it, like, take your time. You're just giving me time to fucking study up too, you know? And so then I started to study, and throughout that process, guys, I was also filing CHP public records request to get the evidence. That's when I was doing it all at the same time, right? My first public records request went at like I think 3:10 right after I filed my notice of appeal. Then I got the evidence, and once I got the evidence, guys, let me tell you, my whole posture shifted. Once I got that evidence, I said, "Oh, it's game on now. Now it's game on because now I got you by the balls. 'Cause I got tangible proof that there's at least enough tangible proof that requires factual development, right? And I'm gonna have an ineffective assistance of counsel claim for sure. And we have to hit him with that first on appeal. That's the first thing we file, ineffective assistance of counsel, and then because I
Well, what's
can't.
going on? Because, well, check it. You want to also go into, I would say, um, all right. So you are getting the record, pulled from the lower court, and what kind of issues are you having on the higher court now, though?
So let me also touch base. It's so locked. It's so much, guys. So if I sound scattered or if I sound like I'm going back and forth, it's really because I am dealing with every obstacle you could possibly deal with. Because let me tell you,
My boy.
when you fuck around and tell them I'm gonna sue you, they best believe they do everything they can to not help you build a record. They do everything they can to prejudice you. They do everything they can to suppress their conduct. They do everything they can to not help, like, you know what I'm saying? Like, they're not going to help me at all. They're not. No judge, the
No.
Court of Appeals, they're not going to help me either. They're like, we know you want to sue all these judges, whether they did what you said or not, we don't know, but we're not going to help you. So
Right.
I'm getting no love. I'm facing every procedural barrier you could possibly think of. So on the record of appeal, when they finally produced me the clerk's transcript, they omitted like 24 filings that I filed that they did not make part of the clerk transcript on the record. They also, the reporter's transcripts is missing like probably 6 to 8 hearings where they say that there was no reporter for those hearings, but that's bullshit. It's a lie. There were. So to deal with that, I had to file a motion to augment. I had to file a motion to augment the record on appeal and include those records. And my dumbass, I didn't follow the right procedures. What I'm supposed to do, what you're supposed to do is you're supposed to send notice to the trial court first, file it within the trial court, serve the DA. Um, Once the trial court gets that notice, they have 10 days to respond. They can either respond directly to you or they can just augment the record, but they have to respond. It's a mandatory duty. Must respond within 10 days. No extension allowed. Then, if they do not respond, then I can file my motion to augment to the appellate division and say and attach their failure to respond. Right? Hey, I filed it and I noticed them on the 10th. We're now on the 21st, and there's no record filed, no response filed. Right in the record. Here's a printout of the case summary or the register of actions that shows that we're on the 21st and there's nothing filed on the 20th. So appellate division, can you now order a augmentation order compelling them to do their duty, right? But I didn't give them notice first. I filed it in the appellate division first, and I uploaded and attached every filing that was omitted. It was like a 200-page. It was like I think a 10-page motion with 190 pages of exhibits, which were my filings. The appellate division took some time, but after about a week and a half, 2 weeks, they did state that they would consider 13 out of the 20 documents that I've attached as part of the appellate record. It says the order said the Court of Appeals, the appellate division considers 13 out of the 20 filed or attached documents as part of the appellate record and then labeled every single one of them. But what the order didn't say is that it orders the trial court to certify them. Now, just because you considered them as part of the appellate record, thank you, but they're not certified yet. They're not certified by the clerk, and they're not a part of the clerk's transcript. So they don't have a clerk's transcript designation, right? So how do I cite these? How do I cite these in my opening brief, right? You can't really cite it. And then additionally, the record says that they weren't filed properly, but they were considered as motions by the trial court, and so they will be considered here because the rule says that any motion that was orally denied must be made available on appeal, right? So now we need the transcripts for those hearings too, but we don't have that. But in the same order that the appellate division says it considers them as part of the appeal, it also set the 30-day trial brief schedule. It says the trial brief schedule commences, trial brief is due on this day, opening brief is due on this day for 30 days out, which is going to be coming up on the 31st, I believe, because the 30th is the Sunday. So the 31st, my opening brief is currently scheduled, and I haven't even, started it yet. But I was like, hold on, this order is good, but it's not good because it doesn't help me. It does give me standing that what I'm requesting has merit, but it doesn't give me any operative force or effect. So then I started studying the rules, and I was like, okay, I got to give them notice. So I immediately gave the trial court notice, and we are coming up on 10 days, I think, on the 23rd. So either tomorrow or Tuesday would be 10 days to see if they've responded. If they don't respond, then I'll request a default judgment, and I also filed an extension of time. So I'm kind of learning the procedural aspects as well. And I'm facing all of these challenges because when the judge originally issued the order, I was like, hold on, this order doesn't do shit for me. So I need to file a writ of mandate for an abuse of discretion because he's not making the clerk certify the record. But then I got into it, and then Cam, I think, mentioned something too. And it's like, hold on, it does do something. It doesn't do something as well, but it does do something. So let me review maybe where I made an error. And then I found that I had made the error. So the judge technically didn't do anything wrong. So I was like, okay, scratch the writ of mandate for the abuse of discretion that I was drafting, put that off to the side, give them notice. And now that's where we're at now. So I'm waiting on them to respond. Now we'll see if they file the clerk's transcript, because when I gave them notice, I did attach the appellate division's order stating that it considered those 13 filings as support. It's like, hey, I already filed a motion with the appellate division. They said it considers these portions as part of the appellate division. So you kind of have to at least, certify those records. And then I need the transcripts. And then I realized, Mike, the record they produced to you on appeal also doesn't have the digital video evidence. I didn't get USBs with the digital video evidence. The exhibits, people's 1, 2, and 3, which is what we have, right? So I have those videos, but I don't know if those are the exact videos that were filed at trial. You see what I'm saying? So you have to be diligent. So how I worded was, I don't have the exact digital evidence that was filed at trial, and I had counsel, and counsel never gave that to me. So I would like the people's exhibits as they were filed at trial to be produced, which is a fair request, because I don't know if what I have is what was filed at trial unless I get what was filed at trial. So give me a copy. So I asked for that. And then I also noticed that the clerk's transcript does not have the Marsden hearing exhibits, because I requested 3 Marsden hearings before trial, because I was really trying to get that attorney out of here. Because I'm like, you didn't do nothing for me, man. You've not communicated. You've not done anything. You've been ineffective. I'm not trying to shit on you, but you're throwing my case. I didn't say that directly, but in my mind, I knew that was going on. So I requested a Marsden hearing, and I said, he hasn't communicated with me for 6 months. There's no communication, Judge. I don't even know his strategy, because he's not. It's not that I have an issue with the way his strategy or his legal conclusions that he's drawing. It's not that I have an issue with that at all. I don't know what they are because he's not talked to me. I've been insulated from my defense, and I said all this at the Marsden hearings. And they did provide me the Marsden transcripts, but at the 3rd Marsden hearing, I submitted the emails with my attorney where he stopped communicating with me for 6 months. And I responded like 4 separate times trying to get him to respond. I even said, hey, I'm concerned. Are you okay? And he never responded. So I submitted that as exhibits in my Marsden hearing to show the judge, like, hey, he's not responded. And the judge still denied my Marsden motion, bro. That's another reversal issue. But they didn't give me, when you submit exhibits at a Marsden hearing, they take them and they put them in a sealed envelope, because you got to remember that's a sealed transcript and it's a sealed hearing. It's not public because it has to do with attorney-client privilege. So he put it in an envelope. He said he'd lodge it into the record, and and that was it. But on appeal, they didn't give me that record, and I need that record. So I filed a renewed motion to augment in the appellate division after I had given them notice of that, to include that as well, and then to include those two items as well, and the contempt order, because the contempt order wasn't included in the clerk's transcript too. So it's like I can't even argue a Sixth Amendment without identifying how I lost my proper rights. So I request the contempt order be lodged in the clerk's transcript and prevent. So guys, when I tell you I'm facing every obstacle possible, they're not giving me a complete record. They're giving me the most minimal that they can. Their own rules tell them they have to give me everything that I have now requested as renewed, and they didn't give it to me in the first place. So you're not following your rules, and none of that fucking matters unless I make a record of it, which is what I've had to do. So where we're at now is we're waiting on them to respond. While after I filed the renewed motion to augment for the video evidence, the Marsden hearing information, and the contempt order, I then filed a request for an extension of time on the trial briefing.
Didn't you get that granted too?
I have not gotten that granted to my knowledge as of yet. I also haven't checked in the last day or two.
Can you check it now while we're here doing
Yeah,
this?
that's what I'm doing right now.
That's funny.
I just uploaded the case summary, and it does not show a minute order submitted yet. Oh, wait.
It's just crazy how like they
8/21. Disposition not completed yet.
Yeah, because it's crazy how much they didn't accept.
Yeah. And so they didn't accept my exhibit and witness lists and definitions as part of the record, which that needs to be a part of the record because it's got my definitions. And my definitions is I set the definitions because remember in court everything's about definitions. What does this mean? What does that mean? Right? Because legalese, the word person has like 8 different meanings, 4 or 5 different meanings, right? You have to define these things for the court. So I defined certain things for the court in definitions. And I used it straight from Black's Law Dictionary, or I defined it if I had a right to define myself, right, for my name. I defined the all caps name as a corporation in the state of California as it is. And then I wrote my name, how I write it, as my common law name. And I defined me as a natural living man and woman with creator endowed rights. So that was not included. And the judge on the appellate division didn't consider it. So in my renewed augmentation motion, I did request that be included too. And I stated that was attached or supposed to be part of my motion to dismiss. So it definitely should be included. So I clarified that. But yeah, I'm going to see if I can download this.
What are you trying to download now?
The minute order. It doesn't say there's a deposition yet, and this is interesting. So it says on 8/21 at 8:30 a.m. there's an ex parte re appellate's request for extension by the judicial officer Marie E. Wood, appellate division. There's a hearing. It says disposition, and it's empty. So she may have not finished her order yet. So perhaps she reviewed it yesterday, reviewed my request, and maybe she'll submit her order tomorrow on Monday or Tuesday. So I'll keep an eye on that. But there should be no reason she doesn't grant it, truly. So yeah, that's where my appeal process is going, guys. That's some of the challenges that I'm finding. And by the way, throughout this process, I learn as I go, right? What I learned is the rules of the court are so important, like so important, because that's the rules that the court is mandated to follow, right? So if you want to hold the court accountable, if you're dealing with what I'm dealing with, which is like they're like throwing procedural barriers, right? And hurdles that I have to get over, like constant hurdles, right? It's like you're taking my focus away from my actual appellate brief and you're making me have to study all this procedural shit just to get a complete record. So you know, they're gonna do that. They might do that. Maybe they won't. Maybe you'll get a fair shake. For me, I'm getting fucked. Um, but the rules were very valuable to me. What I did is I went online, I went to the rules, I copy and pasted all the rules into a Microsoft Word document so that I could upload the text. Because I feel like my Manus operates better when I paste text to it than if it goes and searches and pulls, extracts data from the websites. That's my theory, anyways. I think my Manus works better with me that way. So I did that. And I mean, I found all the rules that would be applicable to me throughout my whole appellate process. And there's a lot. There's a lot of information. And then I uploaded it into my Manus, and me and my Manus have had much more productive sessions since doing that because I make sure that I strictly follow the rules. And since I've done that, my that's when things have started, I think, going in a positive direction for me. So the motion for limited remand, I did file that earlier. They haven't gotten to that yet. So
Okay.
just so we know where that is, they've not gotten to that.
Okay.
But it's important because I filed it almost a month ago.
So at this point, you've literally been in the Superior Court. You've gone up now to the District Court of Appeals. You reached out to the DCA and
Yeah.
then also the Supreme Court as well.
Of California, yeah, but for the contempt. So this is the thing too. Now that we've done that, I think that is set, the stage is set so everybody can understand the procedural posture we're at there. For the direct contempt, I did go to the Supreme Court of California. They summarily denied me for my habeas petition. I then went to the federal court just days before trial. The federal court didn't get to it in time. I went to trial and got convicted. By the time the federal court responded, I had already been convicted. They issued me, they gave me online access, which is something you have to petition for, to get access online through the ECF website so that you can file your documents online. I had 5 days to respond in order to get that access, because they gave me an order granting me access with an access code. I had 5 days to register that access code online, and so I did it in time. So you really got to pay attention to your docket and really pay attention because I didn't get that in mailing until like maybe a day or two before my deadline would have hit. You know what I'm saying? Because the mailing takes 2 days to get to you. So fortunately, I was paying attention to my online record, and as soon as I seen that they submitted it, I paid to download the document and get it and read it. And I was like, okay, cool. So we set up my online access. In that same order, granting me online access, the federal court issued an order to show cause to me why it shouldn't dismiss jurisdiction. And so I filed a supplement response. I filed an opposition to any dismissal claim. And then I filed a notice of errata because I those filings were incorrect. And then I filed what's called a bill of complaint and equity, telling the federal court like, hey, I apologize, but here's a new posture because when I filed originally, I was filing for the contempt order that was restraining me from participating in my defense. But the court didn't get to it in time and I was convicted. And so now I'm restrained by the sentencing memorandum, which is probation. So I attached that. And then I told them, I updated them on the new posture of the federal case. And and then I requested leave to supplement the record further for relief. So then last week, or a week and a half ago, the federal court responded as well. Mind you, I've got trial court, appellate division, court of appeals, and federal court. And I was suing the DMV at the time, right? I didn't even go to my trial at the DMV. I got a default judgment against me because I missed my trial. The judge, man, I'm telling you, the judge that found me probable cause at my first evidentiary hearing at trial transferred himself to my DMV case. Then he continued my trial out like 4 different times. Like weird, bro, weird shit, right? And then I missed the hearing because all the like continuances and everything I was dealing with was all at once. I missed my trial. He dismissed my petition for writ of mandate against the DMV. I also filed another writ of mandate against the CHP because they weren't giving me public records that I was requesting in a timely manner. So I was just doing way too much, guys. I was doing way too much. My CHP mandate is kind of in limbo. They just emailed me last week. I got to respond, but I'm trying to deal with this first. I'll get into that today. I'll probably request a stay in abeyance of that issue, pending this appeal. That way I can focus on one thing at a time instead of being scattered everywhere. So like it's like 5 cases that I'm operating because they're all extended from each other, right? So when the federal court, when they responded to my bill of complaint and equity, they terminated the OSC, the order to show cause, right? So they struck the OSC from the record. They said, okay, you are now in custody with your probation to invoke the court's jurisdiction. Now we will grant you leave to supplement to ensure that you're invoking the court's jurisdiction properly, that you properly identify the parties, and that the court has the authority to grant you the relief that you're requesting. So that's what they did a week and a half ago. That's where we're at now with Cam. That's the document I'm wanting to work on now, is that supplemental response. And now you guys are kind of caught up with the procedural aspect of my case and all the hurdles that we'd be facing.
Does that mean your probation's delayed or whatever?
No, my probation's ongoing. Okay. Yeah, so you got to remember, I was convicted, and I am technically a convicted of the misdemeanor DUI. I didn't even get into that, so I had to do the online classes. I had to do 13 days of a work release program. I had to do, I had to pay all my fines. I had to do all the shit that comes with that to get the Intoxalock system in my car. So I'm dealing with all this stuff all at once, right? I had to meet the terms of my probation. I think on the 26th, I can get my Intoxalock device taken off, and then I'm done with all the terms of my probation. I will have served the 6-month suspension. I've completed my DUI classes already. I did my work release. All that shit's done already. Everything that is an obligation would be done as of the 26th of this month. But I will remain on probation because it's a 3-year probation. So that Marcy's law applies for the following 3 years. If I'm arrested for DUI again, there's stricter punishments. If I kill somebody while under the influence, Marcy's law's effect, it's an automatic homicide felony, so that kind of stuff still applies. And so that is the restraint that I'm using to get into federal court now. And what I'm going to try to do in this supplement response is I'm going to try to state that the contempt order is ground one. It is not necessarily independent, but it's correlated with the overall conviction, right? It had a part to play in the overall conviction. And the state exhaustion process is complete for just that claim. So I'm going to request adjudication of the contempt order as the exhaustion process is complete. And I am attaching all my state petitions and the dispositions, the orders of each petition, as proof that I've exhausted the state process. And then the federal court, I'll ask them, either A, because they do have authority to adjudicate something, even if the state process isn't exhausted, if doing so is vital for upholding someone's right.
Yeah,
so
if there's any kind of prejudice or bias that can be shown whatsoever. Yeah.
Yes. So I think that I can meet that standard as well, but also I think that we meet the exhaustion standard too.
Yeah.
But I'm going to leave that to the hands of the federal court. I'm not going to make the assertion that I've done that. I'm going to present the record and I'm going to state.
Well, you would, but then you put in the alternative as well.
Yes. I'm going to state that I believe that I've met that standard, but I'll leave that to the discretion of the federal court. That way I don't have to prove something. I think it would just give me more leniency if I state it that way. I believe that I've met the exhaustion standard, but I also leave it to the discretion of the federal court to identify and adjudicate whether I have, and to identify the proper process if I haven't, and also provide the alternative option as well. And then we're going to also request a stay in abeyance, that the federal court retains jurisdiction under a stay in abeyance while I continue to the appellate process as well. And hopefully they'll grant that to me. But the goal is to get the contempt order adjudicated, because if they can state, yes, this contempt order is null and void, right? Jurisdictionally, it doesn't meet the requirements. Then now I have a federal order that I can use in my appellate division as another claim for either trial de novo or, even other alternative relief, right? If we don't do a trial de novo, maybe it's a limited remand. Maybe I get the conviction vacated entirely because of the prejudice. Who knows? But there's options. But as it stands, that contempt order has never been adjudicated on the merits in a manner that is capable of being resolute, where there's no further challenges available to it. You know what I'm saying? So hopefully the federal court will do that. And if they do, and it does get vacated, that will help me on my appeal. It'll benefit me. And then eventually later, if it's warranted after factual development, maybe I turn some evidence over to the attorney general and see if he can investigate some claims for potential conspiracy. Depending on what the factual development produces with the CHP. How many CHP officers had access to the records? What did they exactly do? Did they tamper with the evidence? Did they omit things? How did they do it? Did they go through the channels? Did they have a supervisor authorize it? Were there multiple agents that did this? Was there just one? Did the DA know of this or should have known of this, right? Was the DA in on it? That's when we'll start getting to that kind of stuff. And that's a big, big, big issue that might turn into a Bivens case, fucking potentially a RICO case. God knows. Who knows? It's all going to depend on how serious it is.
Sounds like you're gonna make case law.
Yeah, I might, bro. I might establish some precedent. Yeah.
Nice.
There's for sure precedent that I know that I can establish in California court on appeal, by the way. There is no appellate decision in California currently that the mere odor of alcohol and a minor traffic infraction is substantial to warrant further investigation for DUI. There's no case law. However, in alternative cases in states, Wisconsin, Ohio, I think Wyoming, and there's, I think, one other state, they do have case laws that state that is not, that and it's those two items in itself is not enough reasonable articulable suspicion to compel investigation for DUI arrest or for probable cause for a DUI arrest at least. So I will be trying to set that precedent in California on appeal, because that's basically what they used against me to find probable cause. Was the officer testified he smelled alcohol and allegedly I committed a traffic infraction, though that is disputable too. So there's a lot going on, and it's big time.
Yeah, you do got a lot going on, that's for sure. Being in all these avenues like you are and what you've been able to put together is very interesting, because you're trying to bring the attention to certain things.
Yeah.
And it's interesting to see where your attention is going and what you're bringing forth and how they are responding, right?
Yeah.
And yeah, just the battle, honestly, right now with the direct appeal is bringing in everything that you need to. It's
Yeah.
kind of odd that that's not all getting brought in like you needed to, but I think everything that's on the record currently, as far as what they are, I don't get it. If it's already over there, it should be able to be brought in and considered. I just wonder, what is the deficit as far as why they're saying they don't consider it? Did they
Yeah,
provide a
100%.
reasoning on that
No.
by chance?
No.
Okay.
No. Let me pull the exact order. I'll read the order verbatim for you guys.
Like, that's kind of weird. Like, yeah, it's kind of important. I need this in the record. Why are they trying to
All
exclude?
right. So this is the order. Ray defendant's motion to augment, correct, and complete the appellate record pursuant to California Rules of the Court Rule 8.873, and the court's order to extend time to file appellate's opening brief. So the court did extend time for me to file the appellate brief, right? This is what the order says. This court having read and considered defendant's motion to augment, correct, and complete the appellate record, pursuant to the rule of the court, hereby makes the following orders. The court takes judicial notice of its own records and official actions in cases APRI 260034 and SWM 2402170 pursuant to evidence code 452. Those are my case numbers, guys. You could actually look my case up online through the online portal and get access to the docket so you can see what's going on if you want. And then that's page 1. In the footnotes, it says this order addresses both motions filed on July 9th, 2026, which is interesting because one of the motions was an augment to correct the record. The other motion that I filed July 9th was the motion for limited remand. No, it wasn't. I filed that to 28th. Sorry. I think it was a motion to extend time. So, okay. Grants both motions, right? Footnote 2 says many of the documents are not properly entitled as motions. This is what I was trying to get augmented, right? But they were treated by the court as motions and denied, which means they're capable of being part of the record. And then it grants the list of the 13 documents that it considers, right? So that's all we've said so far. The order says just that. The court takes judicial notice. The court takes notice and considers the following attachments to defendant's motion to augment the record as part of the record. Right there, that's big. It considers the following attachments to defendant's motion as part of the record. So it considers it part of the record. And then it lists the 13 options, which I'm not going to read because it's, redundant. And then it says the court denies the remaining request regarding augmentation of the clerk's transcript, reporter's transcripts, and exhibits. And then it says see Cal Rule of the Court 8.861, clerk's transcript, and 865, reporter's transcripts, and 870, exhibits. That's it. That's the order. Nothing else. Then it says the very last page, the court grants defendant's request to extend the time to file the opening appellate brief to 30 days from the date of this order, dated 7/31.
Yeah, so that what trips me out there is the reasoning behind he gave the rules, but
Yeah, the rules.
what within the rules? Have you even read them?
Yeah, of course I've read them.
What are they trying? That's what's crazy is he leaves it open ended as to what he's trying
Yes.
what the theory is or the allegation of said violation within the actual violation in and of itself.
Yeah, he didn't give no explanation, right? So
I mean, he said the rules. Which ones are the rules is showing to there to be a possible violation though?
It's not that they're a possible violation. He's by telling the rules, I'm assuming he's asserting that the rules do not permit augmentation of those specific items. It's the only thing that I can conclude, right? The clerk's transcript is rule 8.861.
Or that he's not accepting them, I thought though.
1.861. So let's read what he says. The court denies the remaining requests regarding augmentation of the clerk's transcript, reporter's transcripts, and exhibits. See the rules. That's it. Nothing more. He doesn't give a reason why. He doesn't give a definition why. So then if I go to the rules that he cited, and read them, it's like, okay, here, let me do this. Let me just copy paste the rules into my Manus. I'll copy paste what the order says. And then we'll see what Manus produces because it'll probably be faster than me trying to read the rules and give you guys an explanation.
Well, I'm just like, what?
Yeah, this is what, like I told you, I face every challenge possible, right? That judge is not going to help me, brother. He's not going to tell me why he's not considering it. They're not going to help me, my man. They probably really dislike me. I don't advise getting on their bad side. But you can't sue people if you don't give them notice, too. So it is what it is.
And what do we got going on in relation to that though?
Well, we're kind of in limbo. 865 and 870. Second, let me just get this pasted in there, and then we can move on. So as it pertains to this order, Cam, where we're at right now is we're waiting on two things: the augmentation, and we're waiting on whether the court will grant me the extension of time. Which, remember, there was a hearing on Friday, yesterday, at 8:30 a.m. allegedly, according to the docket, but there's no disposition yet. So what I'll do is I'll probably call the clerk tomorrow morning, or and Tuesday morning. I'll probably call him every single morning until I get a hold of that disposition, because I need to know: are you going to grant my extension of time, or are you not? Right? There should be no reason they don't grant my extension of time, because I invoked the authority that allows them to do so, and good cause does permit, because currently the records that the court considers is not certified by the clerk. And the rule of the court that says that the record on appeal is complete once the clerk certifies it kind of makes it mandatory to be certified. So it's like, hold on, if you let this go to opening brief, you're proceeding on an uncertified record. That's an appealable issue, you know? That's counterproductive to the court's rules.
What you mean there is it's completely consistent with them not doing anything that they're supposed to do.
Yeah.
As usual. Right.
Yeah. As I'm accustomed to now.
Yeah, so we were both basically sitting in the same spot, except you took a lot more active approach and filed a lot of shit. And I didn't, because I, one, don't have the means to keep driving back and forth because I have to do everything on paper.
Why do you have to do everything in paper?
Well, see, that depends on which court, right? Because I had two, so the one court said, yeah, you can. So I attempted to file one thing online. Then I get a response saying that, oh, you can't file online. Attorneys can't even file online. Okay. So then like a week later, the attorney literally filed online over the weekend on a Saturday, I think.
Yeah.
Or even a Sunday, and somehow managed to land that hearing for that motion was filed online that same following week. Like,
oh,
yeah, so fucking explain that. Right. In the other county, they say you just can't. So,
well, how far is the court from you? Is it so far that it makes it challenging?
Well, yeah, sure.
You could request accommodations.
Oh, right. Yeah.
You could
courts
say
and accommodations don't. Those words don't go together, as far as I know. But
what I'm saying is, if you file a record, remember, everything's about the record. If you have a tangible record, if the court doesn't grant you accommodations, then you can file a writ of mandate in the appellate division and say, hey, can you make these people play by the rules? Just find the rules that permit you to do something, invoke those rules. And then if the court doesn't honor those rules, then you make them honor them by filing a writ of mandate. Remember, your job is to create the conflict that they created. Does that make sense? Your job is to present. There you go. Your job is to present the conflict that they created. But the only way you can present the conflict is by making a filing that they have to respond to, that they don't, or that they have to honor, that they don't. And that creates the conflict. And then if there's no relief that law permits, right? If there's no other adequate relief at law, right? Then you can seek a writ of mandate. But before, you have to exhaust your reliefs at the lowest level. And the law almost always permits you relief. It always, because the law will not permit a wrong without remedy. So there's always a relief permitted somewhere. You just have to find it. Then you invoke it. And then when they don't honor that, then they created the conflict that equity needs to act, because equity will not allow a wrong equity will not permit a wrong without a remedy. So if there's no remedy at the lowest level because they refuse to just do what they're supposed to do, now you have claims, now you have standing to go to the Court of Appeal, file a writ of mandate, and then the Court of Appeal will issue that writ of mandate. And once that happens, they will take you seriously. Once you go through the proper process and procedures, they will take you seriously. I have no doubt in my mind. But you do have to request accommodations first. You have to say, and you have to good cause. Hey, I live, 15, 20 miles from the courthouse. Making me file online is causing me significant financial burden that I just cannot accommodate. Or my means of travel is not consistent for me to be able to constantly go back and forth. I need online access. And if you put it in a declaration attached to a motion, they should grant it for you. There should be no reason not to grant it for you. And then if they don't, you have a record. You have a record. But invoke the rule. Find the rule of the court that permits you to do that. What jurisdiction are you in? Where are you at?
Oh, I'm in Michigan, bro. So it's
That's all right. Listen,
so
bro, I'm not new to this. I'm true to this. You're in Michigan. Where at
yeah.
Michigan?
Barry and Eaton County.
Eaton?
The two cases. Yeah, Eaton. Or Barry, Barry.
So when you're in court, what's on the top of the court documents? Eaton or Barry?
Well, there's two courts because there's two cases. So,
okay, so
yeah,
the one that doesn't allow you to file online, what county is that?
that was Eaton.
Okay. So we're going to go to the Eaton rules of the court. It says they provide Zoom hearings. If they provide remote Zoom hearings, then they should provide online filing. Give me one sec.
Yeah, I requested both to be able to file online and to, appear via Zoom in both. And yeah, just because there's a court rule that says that doesn't mean they don't, they just do whatever. So,
well, but have you ever invoked the court rule in writing, brother?
Okay, so yes and no. So in court, in open court, verbally, I invoked multiple court rules.
Yeah.
Like the pesky ones, like it says that the in all criminal prosecutions, the victim must be identified.
Yeah.
So otherwise, how could you pay restitution and whatnot? Okay, well, the victim is the state.
Yep.
The state, well, it depends on what document you look at, because one says the state of, the other one says people of the state. Of course, we all know that those don't exist. So there's no fucking victim, as always. And I mean, I quoted multiple court rules about, and they just were like, oh, okay. And then they just
Can I stop you first?
Like they always do.
Can I stop you for a second?
Sure.
I'm gonna educate all of us on something that's pertinent. I learned this the same way you're gonna learn it. I learned this the hard way. Have you ever heard or read the case Trinsley versus Pagliaro?
Yeah. Yeah. If
you haven't read it, it's okay. Trinsley versus Pagliaro states that statements from counsel and oral arguments and briefs is not evidence before the court because the counsel cannot be a witness. Blah 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 blah. Right?
Yeah. Yeah.
Okay. That same thing applies to you. If you say it in court, unless you're under oath, it's not in evidence. It's not, and if it's not in writing, it's not properly before the court for consideration.
Which I was under oath. So they swear you in.
So they sworn you in when you said that?
What's that?
They sworn you in when you said that?
Every time, yeah.
Okay.
It's the first thing they do.
Oh.
So I got objections about fucking jurisdiction, like everything.
Okay.
You know how they do, just arrest you, no warrant, take your shit, then they crop out a warrant 2 weeks later with no signature, so on and so forth.
It's a criminal case?
Yep.
Okay.
Yeah, Michigan plays pretty dirty, bro. I'm working with JD too, and they just straight up took his property from him on a default judgment before he ever even had notice of being served. It's like, what? Wasn't even
Yeah,
complete
no, they don't do
services for.
anything here.
Go all the
It
way
wasn't
out
even
to
complete.
oh,
It
oh
wasn't even.
boy.
Yeah, it wasn't even completion of
What's up?
service either, man. It was crazy.
Yeah, anything that would be considered a legal requirement, there are no fucking legal requirements here.
Yeah, there's some fucked up shit going on in Michigan, bro.
I mean,
I have to
none.
admit.
Zero.
Yeah.
Zero. Just like anywhere else. It's not special, but
Nah, y'all
I
just
think it's
there's some
different, a little
pretty.
different
Yeah, it's a
in a
little
court
different.
setting though, because they're just as fucking lawless in the court setting as they are on the street. So
Yeah,
they seem to be a lot more open and real blatant about it, you know. So, I mean, real good example of what I'm talking about. The when they stole my phones for no reason, they because I was videoing, right? So they took those, claimed that they were in the car. They told me they were in the car. So I go to the tow shop to go get my stuff out of the car. There's no phones. So I called dispatch, specifically requested MSP, Michigan State Police. Because in Hastings there's Berry County, there's 3 departments in the town. Hastings PD, Berry County Sheriff's Department, and a little MSP right across the street. So all 3 of them are literally right there. So I requested MSP. So these people literally sent the same 3 people who attacked me and broke my car and punched, kicked me, and tased me, and the same trio. And I have the guy on video admitting that they took my phones without warrants. I said, so you're saying you guys took them without? Correct. Oh, okay. So they lied to me at the department saying that they were in the car. Then I get to the car. They're not in the car. Of course, then they crap out a warrant 2 weeks later. There's no say. There's supposed to be, cover sheet, tabulation, and signatures, and there was none of that. Like, anyway.
And get that right.
And somehow in court, I pointed out that that's not a warrant, right? And, they just went along as it was. I mean, if you just read the first 2 sentences of the warrant itself, right? Or the alleged warrant. The property allegedly belonging to me, right, is in the possession of Berry County Sheriff's Department. Okay, sentence 1. Sentence 2. The property to be searched for and seized, if found. Like, how the hell does it go any farther than that? Sentence 1 literally says that they fucking have it. So how are you going to search for it and seize it if it's found, if you already had it, which is proof that they fucking took it without warrants? Like, it's all so stupid, dude. It's just, you can't make this shit up, bro. Like,
All right.
Hey, Michael,
Yes.
you can use, you said that Steely versus Pagliaro?
Yeah.
it's Trinsley versus Pagliaro.
Or Trinsley,
And
yeah. Trinsley versus
it says 2
Is
things.
hold on. Let me ask my question. Is it a Supreme Court case?
No.
Okay.
It is a federal district court case though.
Okay, thank you. So you can use that.
You can use it, yeah. It's binding precedent.
Yeah, okay, good. So I had brought that up on what was it? In Discord. And I got shot down hard. And I thought, but anyway, yeah. So thank you for clearing that. I think it was Steel City that made a comment towards me. I hope I'm not wrong on this. If I am, sorry. But yeah, Steel City. Yeah, and that's what I was just trying to clarify. If somebody enters good information on our Discord and then a little bit of bad information gets in, it could really mess people up. So thank you very much. I stumbled on that case a week or 2 ago. Yeah, I thought it was really, really good. And I thought it was follows the Constitution.
Yeah, so I'll give you a prime example, guys, that could help you understand how to apply that case. Okay. In my video, that Cam showed today when I said objection, right? The judge said the prosecution has established jurisdiction by an alleged crime happening in the county of Riverside, da 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 da, right? So before the judge was reading that or saying that, and I objected, before he was reading that, the attorney was the one that was saying, because I said I'm challenging jurisdiction, they haven't proven it on the record. The attorney said, "Oh well, and a crime occurred in Riverside County. He committed this crime and he did this, this, and this, and the court has jurisdiction because of this." I should have objected right then and there and said, with respect to the court, oral statements by counsel and brief or argument are not facts or evidence before this court. Can you please mandate the prosecution to identify on the record tangibly with evidence where that happens? Is it on the affidavit of the arrest? Is it in the arrest report? Where are they relying on their facts? If they're relying on their facts from the arrest report, it's not a sworn statement. So that's
second-hand nature can't be entered. Yeah.
So I moved to strike. I moved to strike on those grounds because there's no exception for an unsworn declaration to be considered. If it's on the warrant or the affidavit for the arrest, judge, then can you please have the prosecution identify on what page and what statement the crime was alleged, what exactly was alleged, what are the particular facts, what is the triggering events which led to the arrest, which is the officer's probable cause that he knew at that time of the arrest. It doesn't exist. It's not on the warrant. That is what the elements that I need the prosecution to produce, judge, not making allegations. And judge, I don't need you ruling that the allegations that she made that are unsworn and not supported by any evidence as substantial enough to prove jurisdiction, judge. That's improper.
Right. It's one of the four corners, correct?
Yes. It's within the four corners of the affidavit, the sworn declaration. If it's not within that, there's no case. That's how this is, guys. This is how easy my case is. My case was that easy. All I had to do was at the evidentiary hearing that I had. All I had to do was focus on that warrant, and I didn't do it because I wasn't ready for that evidentiary hearing. I thought that day we were going to set the evidentiary hearing, and then I get to court that day, and then the cops there. And I'm like, what the fuck going on? And then we walk in and the judge's like, all right, we're here for evidentiary hearing. Da, 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 da. I'm like, hold on. I filed a motion to dismiss and suppress, but I never got notice of an evidentiary hearing. I never got notice of the nature of the hearing because I didn't get notice of my compulsory process that I could subpoena witnesses. Otherwise, I would have done that. But I didn't state that stuff at that time, so I erred there. Instead, I just allowed the process to go. That was my fault. I was unprepared, unqualified. I was not ready. I did not know everything that I know now. And
Michael,
so
what about original jurisdiction? Did that ever occur to you?
No.
If you're operating privately under original, maybe did you have a driver's license and all of that?
I have a driver's license. Yeah.
Okay. All right. Never mind then.
Yeah, I wasn't operating with a passport or anything at that time. But still, I did challenge the jurisdiction as best I could. But also, I was in a unique position because I had a public defender assigned to me immediately. Remember, because he was representing me for the prior one still. So as soon as I went for my arraignment, I didn't even have to fill out the fucking paperwork, guys, to request a public defender. He came straight to the court and said, "Judge, I'll be representing Mr. Carey on this issue."
Oh man,
as well.
tell your fucking truck, please.
What was it?
Go ahead.
So yeah, the public defender came straight. I didn't even have to fill out the request for a public defender, and with my information and saying that I was indigent, I didn't even have to do that because as soon as I came to court for my arraignment on the ticket, he seen me. He's like, "Hey, what are you doing here?" I was like, "I got another one." He's like, "All right, I'm gonna represent you here too." And we went straight to the court, and the court accepted his appointment. So, and then he entered a plea on my behalf. So technically, I waived personal jurisdiction challenges. Right. Is what it is. So.
I'm not doubting you, Michael, and I want to ask Cam what me and Michael just talked about that case. Cam, can you kind of chime in here? Because I've only been out this a year. I found Wisedome about 8-9 months ago, and I've been serving notices of liability and all that. So I got to pick up everything I can from the court, the game on the courtroom or in the courtroom. So the next time when it happens and I do have to go to court, they're not going to ruin me.
Hey, real quick. I'm so sorry. I'm gonna help you with that question too with Cam, but I got to touch base on Homeboy, from Michigan for e-filing. Are you still with us?
Yes, sir.
That's Tony. That's Tony. Hey,
Okay.
Tony.
Have you ever heard of True Filing?
I've heard the name, but
Have you ever tried to use it?
no.
Okay, so I did some research for you, and your California, your Michigan rules of the court states that you do have access to e-file, but it's through True Filing. So so let's see. Well, there's a Michigan Judiciary electronic filing system, MyFile. That's the state's MyFile system. Currently lists Eaton County as the 56A District Court as an available court, so you can do it through them. Eaton County's current page says the 56th District Court Civil Department. All right, you're not in civil, so this is the civil department does true filing, but the MyFile is what Eaton County lists as their e-filing option. And the rules specifically state they support you to file online because let's see. Rule MCR 1.109G3A states a court shall accept electronic filing and permit electronic services of documents. Rule 1.09G1B states the electronic transmission of data and documents to the court through the electronic filing system must be allowed. So e-filing for you is absolutely an option. And I was going to say it was baffling me that you were saying that they said you couldn't. What I would take from that seems like they were just not helping you with the right process on how to do so. Maybe they were stating you can't do it the way that you were trying to do it. I don't know. That's what I would presume, because courts will never tell you the answer. They're never going to give you the solution, especially if they're, in Michigan, if they're anything like Riverside County, they're fucking assholes. They're not going to help you. But the rules that I'm seeing, the rules of the court that I looked up, they say that you definitely have that ability to. So maybe look into MyFile, MIFILE, for filing. MCR 101.9 is your rule of the court that allows you to do so. You don't have to file anything in the court to request this, brother. You could just go online and start doing it. You can just start filing your shit online. They'll approve it. They'll have to. And you can serve the DA as well. Just find the DA's email address, or call and ask for it. Or if they won't give their work address, email address, then ask for an email address that accepts service, because they have to give you something. And then you can say, hey, this is a public records request if you have to, you know what I'm saying? And if I'm making a public records request orally over the phone, you have to provide me with this information. He's a public servant. He has to have a public service email address for communications, especially if he's prosecuting me. And then, yeah, you could just draft your documents, file them online. Look into that stuff. MCR 1.109. And then what it pulled for me was MyFile, was the Michigan Judiciary Electronic Filing System. I click on it, and it looks like you could sign up and everything. Welcome to MyFile, the Michigan Judiciary's electronic filing system for filing and serving documents online. The website does not provide public access to court records. If you would like to obtain a court record, please contact the court directly. But it seems like this option is available to you.
Yeah. So what they pulled in Eaton County was they told me that, yes, it is allowed. I said, okay. So I sent them one document. It was about the bind over, because how they pull all this bullshit here. So the traffic, right? They use the traffic to manufacture criminal charges.
Yeah.
Like, dude, I could tell you these public acts that they did, like.
For sure.
But anyways, yeah, no, it really just mind-boggling. Like, I invoked all this stuff in court. The Eaton County Court told me that I could file online. I could not only could I file documents online, but also I could just communications, whatever. So yeah. I had sent them literally, it's like 2 sentences about the bind over, right? Because they use the traffic to get you into the district court, right? Yep. While you're going through the district court, about the traffic, if anything bigger was alleged, like a felony, for example, the felony, so they deal with the traffic stuff in district. then they bind the felonies over to circuit. Well, when they do that, you read the language of the statute of the bind over, they basically dismiss the district issue and bind over the felony. So just in the act of the bind over literally dismisses, of course they don't tell you that and they just default on it anyway, but so then they bind over to circuit, the felonies over to circuit. So it was a 1 page, like 2 sentences about agreeing to the dismissal of the district stuff per the bind over, right? 1 page. I send that to them. They respond saying that e-filings, any e-filing, is not allowed. Not even by attorneys. Not
In
this is
federal
what
court.
No. This is what after telling me, it was the same clerks who told me that I could e-file in the first place. Then after I sent them that one document, I was trying to get confirmation that they had received it, and they were like, "Oh yeah, by the way," they responded with this letter saying that no one is allowed to e-file, not even attorneys. And then, ironically enough, it wasn't a week later, my alleged forced counsel e-filed a motion for a competency exam over the weekend and somehow got a hearing for that same filing that same week. So I invoked a lot.
Okay.
And they just completely ignored They completely ignored every single filing that I filed in both courts.
Well, shit.
And then they used in Eaton County, they just forced this other attorney on. Dude, I fired him in fucking court. And then he stated for the record multiple times over and over how he works for the court.
Yeah.
Right.
Yeah. He does.
Yeah.
So
not my counsel guy, but
so
they
you
use
guys are
that
aware-
attorney to dodge all. I'm assuming they use that attorney to dodge every single thing that I filed.
Okay, let me educate all of us on one thing to be clear, okay, how the proper way to do this is, because I made the same mistake. I don't want you guys to continue to repeat this, and I just heard you tell me you made the same mistake I did, where you fired him in court. Guys, so court-appointed counsel is appointed by the court. Now, if you fire that attorney, you're creating conflict with the court now, not with the DA, now with the court. And technically, you are in dishonor and you don't even know it. And so the court is going to treat you as such. So the proper process, guys, is if you get court-appointed counsel, you accept that appointment of counsel because they gave you a privilege, they gave you a benefit. And you gotta remember, if you're in their jurisdiction already, if you've not challenged personal jurisdiction from the go and you got dismissed, if you didn't file a demurrer or a plea and abatement or a conditional offer of acceptance or a bill of complaint, if you didn't file those things before ever having an arraignment, if you've been arraigned, you've pled and you're in their jurisdiction, or if you've shown up to court and you've had a counsel plea for you or whatever the case, if you're in there, the best thing to do when you get court-appointed counsel is to not conflict with the counsel, but you have to set the terms of the counsel agreement, right? Let me pull something for you guys. My phone's like dying already, so I'm like trying to charge it at the same time. I'm gonna read something for you guys that I have kind of saved in my own little back pocket that's useful on how to handle that kind of situation with counsel. Now, you want to accept the court's appointment because you want to stay in honor, but you want to make sure that the counsel does what you instruct him to do. And as long as you're instructing him to do stuff that makes sense, there can be no real conflict, right? You just have to instruct him properly and effectively. So you can file what's called an acceptance by administrative order to perform equitable duties to the public defender by letter rogatory. So you can send your counsel, your court-appointed counselor, a letter rogatory. And if you don't know what that is, type it into Google real quick. Look it up in Black's Law Dictionary when you get time. Take notes as I read this stuff to you guys because this could be very important to you guys so that you don't end up like me and him, where you've now been basically considered in dishonor, and now you're getting competency hearings, and they're building a record against you for, you know what I mean, which is what you don't want. You want to keep your record clean. You want to stay in honor. You want to show the court like, hey, I'm mature to handle my businesses. I know how these proceedings work. I know how, the law works. I respect the court. You never want to be in conflict with the court. You want to be in conflict with the DA. So you send your counsel a letter of rogatory on how to perform his duties on your behalf. At the top, I put notice to agent is notice to principal, and notice to principal is notice to agent, applicable to all successors and assigns. That saves you, that prevents you from him recusing himself as your counsel, or creating him saying, oh, there's conflict, I want to remove myself, and then you get new counsel assigned, and now you have to do it all over again. If you put that little clause, applicable to all successors and assigns, it's applicable to anybody else. It's now on the court record. Remember, the court's assigning you these counsels, so the second they do so, they have to inform the counsel of, hey, there's a letter of rogatory that's in perpetuity for this matter, right? And then you can state your introduction comes now, you, the living man, appearing specially and not generally, avoiding all unintentional joinder as the authorized agent for the named defendant estate, right? Your name in all caps, who gives his or her acceptance by administrative order to perform equitable duties, or in this case, for mine, it's equitable subrogation, to the public defender by letter rogatory. And then you could state everything that you want counsel to perform in statements. I don't consent to waiving any rights ever. I don't consent to undisclosed suretyship. I would like the counsel to obtain all administrative records, any accounting issues, all bonds and securities opened in the alleged defendant's name. I would like that to be produced for my records, to avoid any skip tax avoidance, blah blah blah. My stuff is suited for like the private side of court, which is, I'm not going to get into all that with you guys, but you can instruct your counsel on how to appear. So you can say citation to appear, and then you instruct who this is going to: the public defender, the prosecuting attorney, the clerk of the court, the judge, case trustee, the state controller, the judiciary auditor, the Department of Budget and Finance. Like, you have to list every party that you want this letter of rogatory to be noticed of so it can be honored, right? And you have to have their name and address. You have to pull this stuff. It's research. It's a lot of fucking work. But you pull these things and then you deliver this letter of rogatory to every single one of them so everyone's noticed, right? Now the attorney cannot act contrary to your wishes. And then you stay in honor. And if the attorney does act contrary to your wishes, then he is in dishonor, and then you can move that before the court in a motion to assign new counsel. And you attach your letter of rogatory as Exhibit A. Hey, Judge, I've requested and I have on file a letter of rogatory instruction on how I would like my counsel to perform his duties. He just has some guidelines he's got to follow. As long as he follows these guidelines, however he decides to do his work is up to his discretion. But there's certain guidelines he can't file. He cannot, disobey because it injures or prejudices me.
Right.
And he's done that. So now, Judge, I would like you to remove him from counsel and reassign me new counsel. And then the judge will have to do it, bro. And if they don't do it, then you file a writ of mandate and you have a record. By the way, this is one document, one powerful document is the only record you'll need to remove him and get new counsel. And now your counsel is your fucking puppet, bro. And you got to remember, they are an officer of the court. Their duty to the court does exceed their duty to the client, but that's under corpus juris secundum. But volume 7, section 76. But they still have a duty to the client as an outright duty to inherently perform to your benefit.
Yeah. And to what you're requesting that they.
Yes.
Yeah, the perspective in which so like if you're wanting a certain avenue to even be done as far as representation, then they don't abide, that's an issue. So yeah, there's no doubt about it.
Yes, guys. And so you basically, like, for mine, right? I'm like, I don't waive personal jurisdiction, because if you don't state that on the record before he appears for you, the second he appears for you on your behalf, boom, you've waived jurisdiction to the court, personal jurisdiction. But if you file this letter of rogatory before you ever come before the court, this is in future proceedings, guys, so you can do this in the future, and you've instructed him that he appears specially on your behalf, not generally. He can do that. Attorneys can appear specially. And especially if they're instructed to. But you got to remember, everything in court is procedures. Procedures and the law. And the more that I've studied this, I've gotten a lot less into the sovereign citizen theories, avenue route, because they use that term in a negative connotation. You can't be a sovereign and a citizen in the same sentence without conflicting with each other. So you get the existence of one does not omit the existence of another.
Well,
But
we look at it a little bit different, which
yeah,
is,
yeah, we might,
like the sovereign and then citizen. Citizen is tied into the American way
Yeah.
of life, right? It's
Mhm.
it's more of the moral side of
It's
things.
governmental, yeah.
It's not necessarily tied directly, which again they've just kind of moved it to
Yeah.
being comprehended. But a citizen, as far as an American has a really strong duty, bro.
Yeah.
That's to stand with magnanimity,
A
and
very
with
strong
that,
civic duty.
it's it's upholding certain morals and values that elevate others in God's,
Yep.
under God, truly within that comprehension of understanding where we come from, that we're all a creation of the Creator. So
Yes.
that duty that includes the citizen tie there, not
Yeah.
the one that's statutorily brought in now. Like
I
you
agree.
see, like in the 1940 Joint Resolution, it was more
Yep.
tied into a deeper principle of our moral duties, right, and responsibilities as Americans. And with that being said, like they've just changed it. So, when and you're exactly.
I
I mean,
agree.
I'm on video. Back in 2023, saying you can't be a sovereign citizen. But
Yeah.
since then, I've kind of changed it just because of understanding actually there's a deeper philosophical meaning here that is before everything got flipped or that even mindset, because overall you are a citizen of America as an
Yep.
American moral duty, but to say that there's any as far as I mean, maybe in your sense because you was in the military, so you did at least pledge some
Mhm.
allegiance at one time,
Yep.
in that form and fashion. But at this time, you more, in the public, which is private side of things, and yeah, it's just you gotta look at it deeper, bro. Yeah, the
Yeah.
deeper you get on these, is the better that you're gonna be able to
Well,
move and shake. Um, go ahead. Sorry.
no,
The
you're good.
capital C.
The one big thing with that sovereign citizen term. So it's oxymoronic
Yeah.
in the sense of England, right? Because the sovereign was the king.
Yeah.
The peasants are the peasants. Okay, great. So in that context, right, it's a complete oxymoron. You can't be the king and the peasant at the same time. When they came to America, right, the whole premise was there is no damn king.
Yeah.
And that power that the king holds in England, the people hold in the States.
Yeah. And so
So
the citizens on the moral aspect of what he's saying there is the power that is bestowed upon the people. Like, but you have to have your duties in that. And that's where the whole self-governance ties in. As long as you're in that self-governing realm of things, then you hold all that power. That's the whole point of it. And it's a citizen of that power, which is of true Americanism, which is self-governance, right? And that's the whole thing. As far as what they've taken it away from is that deeper philosophical meaning of sovereign citizen, or of the sovereign kingship, like Tony's saying, collectively together as Americans within self-governance. And that's where that whole, I believe, sovereign citizen got taken away from, because that was the meaning of that. Once you hit 21 at that point in time, you hit there, or yeah, it was 21 at that time, was a moral responsibility to really be that person that uplifted others, and established the deeper rights and stand up for that. And it's just changed so much since then. And we can see why, people do a lot better when they're controlled rather than just living free, right? You can push whatever agenda you need to push to get control. And hey, man, I ain't knocking what you do. Do what you want to do. It's just at the same time, we can do what we want to do too, and that doesn't bring harm. That doesn't bring harm to anybody. It instills empowerment and enlightenment and freedom, and the freedom of expression of rights completely without harming another. Whether that freedom of expression some may not like. That's just part of being an American. But at the same time too, like meaningless administrative violations that turn into crimes that brings irreparable harm to people over a long period of time are just a captivation of some liberty without due process that is complete with a compelling interest of the public and or constitutional right being imposed upon them within the limitations of the corporate state, which is thereby a principle, or a subsidiary of the federal in and of itself, just allows ones to comprehend that, yeah, you got to go after it. Now, sometimes we may want to get too deep in relation to it. And sometimes you may just want to say, fuck that. I'm just going on the private side and I'm just going to issue it out like this and not even argue the facts on that bad boy. Whatever the situation or perspective may be, um, man, it's just crazy to me though that the allocation of the rights got taken away for self-representation. Maybe you pushed a little bit too hard on his ass, but the contempt in and of itself is kind of crazy because there was no screaming or yelling on your behalf. There was no, no. Yeah, it was just so weird
No
to me.
direct insults, no nothing, bro.
Yeah, that one to me would really bog me down on making sure that element right there is heavily fought, bro. I wouldn't give that one up at all. Because yeah, if there's no real true signs of like belligerent, which they want to say, I guess, is disorderly conduct, and just to actually hear that little bit of where, again, coming back up to where they're bringing that forward on saying 2 days because I've objected or I've questioned for my rights to be heard is just crazy to me. Um, that's just wild to me. I don't understand.
100%.
Um, that would be
The judge panicked.
that would be a serious issue, bro, for me.
Listen, I'm gonna tell y'all a little inside news. So, I filed that stuff saying I need an evidentiary hearing to address it. The judge panicked, bro, because he knew he knows what's going on. He knows he knows what the CHP did. But I promise you, they all eat lunch.
Yeah,
My bad. I was eating a little piece of chocolate, but they all know what has been going on. The judges, I have no doubt the judges know it. They're not they're not ignorant of what's going on. I promise you, the DA knows what's going on. The CHP, they're all working together. The CHP told the DA we need help. The DA said we got you. The DA told the judges we need help. Judges said we got you. Cool. This is what we do. This is what we do in Riverside County. It's a business. We got their back. You got our back. We all have each other's back, no matter what.
So my thing is when you get to a certain point, how are you going to combat the judicial immunity?
Well, it depends on what we develop through the factual development. It all depends on what is developed in factual development.
Yeah, because like Joe's about to go through this, right now we're gonna have to try to find a loophole for the judicial immunity.
So,
Right?
so this is the thing, Cam. You have to give them notice that they can be held liable in their administrative capacity before they commit the damage. To my understanding, in order to strip judicial immunity. To my understanding, it's super hard to strip. One of the reasons why is because any judge, when they act, they could just say, I was acting in the capacity that I thought that I was, empowered to act. I was acting judicially to the best of my ability, right? But if you give them notice beforehand that, like, hey, if you act in this specific manner, you can be held liable and your judicial immunity can be stripped, which I did do in my affidavit. You'll see it if you look at the affidavit attached to the motion to dismiss and motion to suppress. I think points 22. It states very clearly that judicial immunity can be lost if they act without jurisdiction.
Okay,
And if
good.
they act with in opposition to the Constitution, because no man is above the Constitution. No man is so high above the law that they cannot be held liable. So I gave them notice in that affidavit, and it's on the record. So one of my theories is they know this. And one of my theories is that judge also knows that I put on that record that I would hold the prosecution accountable for malicious prosecution. So he probably got my demand for stay and request for evidentiary hearing and said, oh, fuck, he's on to us. I can't let him proceed. I don't know what he knows, but I don't want him to put it on the record. I don't want him to create a record. I want to send this to trial because I'm thinking the judge thought that if I send this to trial before he addresses it, he waives arguments that were not raised pre-trial. Because there's a case, U.S. versus Williams, that states that known defenses that were not raised before trial can be waived on appeal and waived from further consideration and further factual development. However, what that judge probably didn't realize, he probably wasn't keen on Strickland versus Green and U.S. versus Olson and Banks versus Dretke, which is huge, right? Which states, those cases state that the prosecution may not hide, or the notion that the prosecution may hide and the defendant must seek is untenable in law. So the prosecution cannot hide evidence or hide certain things from the defense and then claim the defense waived those arguments on appeal if they become discovered after conviction. And then US versus Olson on the en banc rehearing, right? Chief Justice Kozinski stated that he's the Chief Justice of the Ninth Circuit in 2013. He stated that he's going to express clearly in this dissent that if the prosecution hides or violates Brady, then they will lose their ill-begotten conviction. And that the only way to ensure that Brady is not constantly violated, as it has become a pandemic amongst our community, is what he says, the only way to hold Brady account or hold these prosecutors accountable for violating Brady is for the judges to make them accountable. He said that in his dissent. So that's the Chief Justice of our circuit, Ninth Circuit, well, mine especially, giving instruction. Now it's not binding precedent, but it's very powerful instruction to the judiciary of the Ninth Circuit to hold prosecutions accountable for any Brady violations, right? So I'm thinking the judge wasn't aware of all that stuff. He probably, I mean, no judge knows everything, right? I learned all that stuff afterwards. I learned all that stuff recently. So he was probably thinking, if I hold this guy in contempt and send him to trial immediately or as soon as possible, he'll waive an evidentiary hearing. He'll have no factual development, and maybe he'll win at trial and let it go. Or maybe he'll appeal and maybe he won't discover us, right? Maybe if I beat him down, hold him in contempt, and scare him enough that he'll stop the fight. Maybe he'll stop the fight. Maybe he'll give up. Maybe he'll just let the assigned counsel take over and just handle the business and get him dismissal. Because my counsel that they assigned me, when I talked to him in person, because he wouldn't email me, he stopped emailing me because I wanted all my communication in writing. And I knew what they were doing. I knew exactly what they were doing. And when he would talk to me in person, he kept telling me, "Don't worry, man, I got this. Like I've done defenses on DUIs plenty of times. You know," he's like, "I've got my motions and Lamines drafted up. You know, I've got some strong points to suppress certain statements that you may have said, yada yada yada, all these things, right?" He talked it up like he had this defense in the bag, right? But then somehow we still lose that trial because the prosecution brought in that really prejudicial evidence of me fucking being belligerent post arrest, telling the officer he's a scumbag and a piece of shit and he shouldn't be fucking arresting people on suspicion alone, and telling him that I was going to sue him. Well, a jury that doesn't know the context is going to see that and be like, "Oh, this guy's fucking dick, like asshole," right? The cop's just doing his fucking job, and he's literally verbally assaulting the cop. He's clearly intoxicated, right? His face isn't flushed, his eyes aren't glossy, but we can't tell that. But we can tell he's really combative. He's got to be intoxicated, right? That's what I'm assuming the jury came up with. So,
Right, because talking's a crime, bro. Existing in public's a crime.
100%. 100%. So, I'm thinking that the judge held me in contempt, thinking that he's gonna, scare me, silence me, shut me down, maybe intimidate me enough for me to give up the fight, right? And I think he panicked. And the reason I think he panicked is because he did that. He held me in contempt. Let me tell you what happened after he held me in contempt. He got removed from the bench. I didn't file any complaints yet because I don't have transcripts. But he got removed from the bench. He got reassigned. Probably by the clerk of the court. He got reassigned. Now, I don't know what that means, right? But I can only pull one or two things together. He did something very, very bad. The people above him know it, and they're not happy with him, right? And doesn't mean they're going to give up the fight. They're still going to try and defend him and protect him and do everything they can. But that tells me people above him weren't happy. Now I'm going to tell you guys what happened. When I got arrested, I got thrown into jail. It was like 4 p.m. They let me out the following morning at like 9:30. They were supposed to have me 2 days, right? But I got arrested Thursday. So if they held me 2 days, I would be released on Saturday, and they don't release people on the weekend. So I would have to been in containment through Friday or through Monday. They released me out Friday morning. While I was in jail, one of the deputies came to me and said, "Yo, they dropped all the charges, bro." I'm like, "You're lying." He's like, "No, dude, I'm looking at the screen and all your charges just came off the screen." He's like, "The only time they do that is if the DA has dropped charges." He's like, "I wouldn't lie to you."
The document he spoke about, it can't go in the chat.
What was it?
The document that you spoke about, as far as giving them warnings,
Yeah.
that can't go into the chat.
It is. It's in the chat.
Oh, it is?
Yeah. If I at the end of the chat, if there's a supplemental exhibit for the federal filing, it's 420 pages. The document's in there somewhere.
Okay.
It's attached to Exhibit 6, which is the Supreme Court petition, and it's attached as an exhibit to that. Under Exhibit A, I believe, the motion to dismiss and suppress, and then the DA's opposition was Exhibit B, and then I attached a couple other filings trying to prove judicial embroilment. Right. Anyways, those filings I'm not very happy with. They're poorly done, but it is what it is. Anyways, the officer said, "Yeah, they dropped all the charges. I'm not playing." He's like, "That's why we're moving you out of public holding into private holding upstairs. You're gonna get moved to a different room. We're changing your uniform. You're not going to public housing, and we're gonna be letting you out soon." I'm like, "Are you serious?" He's like, "Yeah." He's like, "Look, man, I don't know what you did or what you filed or if you did anything wrong or didn't do anything wrong, but based on the conversation you and I had, because he asked me what I did wrong. He's like, "You're here on court remand." He's like, "Did we never get somebody on court remand? What'd you do?" I was like, "Bro, I didn't do anything wrong. The judge was being an asshole, and all I did was try to tell him that he was incorrect and try to apply my law to the best of my defense and object to his rulings, and he wasn't having it. He just threw me in jail." he's like, He's like, "No, there's got to be more to it." I was like, "Nope." And so we had that conversation earlier when I first got arrested. And then this was later on in the night, and he came back and he told me that. And I'm thinking, well, shit, they dropped the charges. It worked, right? Because I was kind of bluffing about knowing that they tampered with the evidence. I didn't have tangible proof they tampered with it. I just knew that the officer testified that certain incidents happened and that those incidents weren't in the video. So I was going to use that, like the exhibits from the transcript, to cross-examine and say, "See, he testified that this incident happened, but it's not on the video. Something's missing." And then I was going to request, do some more evidentiary work where I subpoena documentation, subpoena the records that I needed, and we would have figured it out as we went. But I was kind of bluffing to an extent when I said it because I really, that was my ace in the hole. I was keeping it in my back pocket. I hadn't raised it yet because I was trying to get the case dismissed on the warrant. And that I was going to keep in my back hole as like my ace in the hole. And I had to use it because the judge was like, "Hey, come back in 3 days for trial. You start trial." And I was like, "Well, fuck, I'm definitely not ready for trial. So let me throw my ace in the hole out." And it worked. But unfortunately, it worked too well because he held me in contempt and threw me in jail. So then when they released me the following morning, I go to sign for my inventory. When you get arrested, your inventory is taken, then you sign for your inventory when I get out. When I went to sign for the inventory, guys, there was a big packet of papers underneath my inventory sheet. And the deputy smacked it on the table and said, "Here, go ahead and sign so we can get you up out of here." And I was like, "Hold on, what's all this shit underneath it?" He's like, "What do you mean, man? Just go ahead and sign the paper so we can get you out of here. We're trying to get you in and out. We got a whole bunch of people to book." I'm like, "Look, man, there's a bunch of paperwork right here. I need to read this." And he wouldn't let go of it. And I'm like, "I need to read this stuff back here." And he's like, "Man, whatever." And he let go of it. And I started looking through it. And guess what? Guess what that stack of paperwork was, guys? What do you guys think it was?
You can't sue them.
What do you think it was? You're on the right track.
Release
An
liability.
admission of guilt.
It was an offer of dismissal. They offered to dismiss the case for insufficient warrant. Now I'm going to ask you, what do you think was attached to that offer?
You just give up everything.
Nope. It was a arbitration agreement that I wouldn't sue them.
Wow.
Yep. Yep. And guys, I asked for a copy of it and they wouldn't give me a copy. And I said, "I need a copy of this." He wouldn't give me a copy. Now, in law, if you sign something, any paperwork underneath it, you're liable to. If you didn't go through that contract, you signed for it. It was attached. If it was touching, it was attached. And if you signed for it, you consented to everything in there. And if you didn't go through those paperworks and you didn't read everything, it's your fault. Because he who can be deceived shall be deceived, even in contract law. They gave me an offer of consideration, and they gave me an opportunity to review it. If I choose to review it or not, that's on me. But I was smart enough and intelligent enough to see what they were doing. And I caught it. Thanks, baby. And and then as soon as I seen it and I seen the offer of dismissal with the arbitration agreement, I looked at the officer. I said, "Is your body cam going?" He said, "Yes, it is." Why do you think they were recording that, guys?
Could you have signed it without recourse under duress?
That's exactly what I did.
Yes.
That's exactly what I did. I said,
You
"Is your
didn't just
body camera?"
refuse. You didn't just sign the release and refuse to sign that arbitration form.
Of course I did. Of course I did. I signed my release form. I said, "I do not consent to this packet. I need a package of this to take home with me." He said, we don't have a copy." I'm like, "I need a copy. Who's got a copy?" He's like, "I got to give this to my sergeant." I'm like, "Well, your sergeant needs to make me a copy and give it to me." He's like, "He's not doing that." I'm like, "Okay, I'm gonna subpoena or I'm gonna public records request your body cam." Unfortunately, my dumbass never did it because I was facing all the other obstacles throughout, and just got distracted. But I did sign my inventory sheet, and I signed under duress and coercion, no consent without recourse, and then I struck a line through the front page of their document. And I gave it to him, and then he looked at it and he read it out loud in front of his body cam. He showed his body cam and he read it. Why do you think he was doing that, guys? Because if I had just signed that document, now they have video evidence proof that I agreed to arbitrate. And if I ever tried to sue them, they look, he signed it and we're good. Judge, you know what I'm saying? They tried that shit with me. And listen, the guy said that the charges already came off the books, right? But yet I was still prosecuted. So what do you think is going to happen when I do a very thorough investigation and I have a master auditor audit the record and audit the systems as it pertains to my case? What if that master auditor finds that the charges were dropped by the DA at that time, like they said, because there'll be a footnote, an electronic digital footprint of it. And what if those charges were reinstated because I didn't sign their document?
Wow.
What kind of fraud is that? What kind of fraud do you think that is, guys?
Coercive.
Malicious prosecution, guaranteed. You dismiss charges, claimed insufficient warrant, and then still brought charges against me, sent me to trial, convicted me.
Set that precedent.
My shit's bonkers, guys.
It's called misconduct and retaliation.
Extreme official
Yeah.
misconduct.
Yep. And I don't know if you know this one, but the subsection 1001 of Title 18, knowingly and willingly falsifying public records and documents.
Yep.
That's a fucking huge one.
Well aware.
Yeah, the judicial immunity is going to be a big one. You got to overcome that thing, bro.
Yeah.
Well, I think on that one, I think the Tanawa, right? Because I've heard Mike say a couple times that they're acting in a judicial capacity, but we all know that they're not acting judicially. They're
acting
pretending.
administratively.
Exactly. See, but they're pretending that they're acting judicially, right? So just like the premise, you go into a bank with a squirt gun, right? That squirt gun, even though it wasn't actually an arm, and you weren't actually putting anybody, people are going to take it as if it's real, right? So that's the same shit that they're doing in court. They're acting administratively, claiming that it's judicial. So they're acting in their administrative capacity, not their judicial capacity, because judicial immunity only applies to people who are acting in a judicial capacity. Yeah.
And here.
Yeah, but Tony, you can call in their judicial capacity while they administer colorable law over you by demanding it, by requiring it.
So
they have a judicial cap. They can
but
put
it's
it
not
on.
though.
They do.
What?
Hold on. They do. They have a judicial path. Even if they're acting administratively, they can claim judicial immunity if they act in a judicial capacity. However, I believe if you do review my testimony attached to the motion to dismiss, I believe I put in there everything I need to strip them of their judicial immunity. Why? Because I asked for their oath of office. I asked that they prove and establish their delegation of authority letter, delegation of authority from Congress, that they can act judicially. And I asked the certain questions that put them on that judicial path. Now, if they provided me those things, boom, you're good to go. They never provided those things. So guess what? Their silence is acquiescence, that they're not acting judicially. That's going to be the path that I try and attack to strip them of judicial immunity. Look, hey, look, federal judge, I gave them notice. I asked them for this. I asked them to prove they were acting in a judicial capacity. I wanted to ensure they were acting judicially. Nobody ever responded. The DA didn't respond. The judge didn't respond. Nobody responded. Nobody provided me with anything. So their silence can only equate to what? Either one or two things. Silence when there's a moral or obligatory duty to speak can only equate to fraud. That's a federal case. That's a federal case. They've already held that, right? So either you're committing fraud or you're knowingly and intelligently consenting to that you're acting administratively because you didn't respond to my judicial inquiries. One of two options. That's why I think that I can strip their judicial immunity because of that document. It's pretty blatant and it's pretty blunt, but it is what it is. And that's also why I'm facing all the adversariness that I am, because they ain't fucking with me. They know what I'm doing and they don't like it. And they protect their own.
Damn, man. Hey, I had a question because you went so far. I put in a document that was a special appearance and reservation of rights. Do you think that's going to be enough? Or yeah, it was notice of special appearance and reservation of rights. Do you think that?
What I always do with those is I'll bring it in almost every document, to be honest with you,
Me too.
as like a preliminary statement. That's
I was
all.
going to, and then I was with this, with this other program, and it stripped all that language out, so I just put it all in one document. But I guess going forward, I'll switch it back in and put throughout. But I don't know.
Yeah, I usually do because it's, you're just through every document you're bringing forth. Hey, I'm standing on what I'm bringing my forth as, rather than not.
30 minutes. Y'all's gonna be taking on 30 minutes.
So, but yeah, that's what I would say on that one. I bring it forth through every single one.
Well, that's really interesting about stripping their immunity by giving them notice. Do you have that document?
Again, that's on this argument side of it, though, right? That's saying, okay, well, we're going to operate within the rules of the court in and of itself and not challenge the fiduciary side of it, right? So that corporate side. There's of course two elements: the slower side and getting everything done through the admin as far as their rules, whether it's criminal or procedure is concerned. There's no doubt, but that doesn't mean right off the bat you can't challenge it, with a very strong stance on the corporate side of things and limitations thereof. And that's why I say the affidavits are so important because, like, they don't ever respond to affidavits. One thing I've always noticed is they will never respond to an affidavit.
Ever. And then you know what? I had one of the judges tell me we don't do affidavits in criminal court. I said, well,
What are you talking about?
I said, how the fuck the cop bring charges against me on just hearsay? If he didn't submit an affidavit, how's the state bringing charges, Judge? He's like, we do facts and evidence. It's the evidence, the WMVAR evidence that he's using to bring charges against you. I thought, oh, well, charges were brought against me and I was never produced with that evidence. So I don't know what you're talking about.
Right.
Insane. That judge told me right to my face, we don't do affidavits in criminal law. What do you mean, bro? Says who? He says we do testimony and evidence.
Any stupid shit.
He said we do testimony and evidence. I said, Judge, my document is entitled Testimony of Michael Andrew Carey et al. Affidavit. It's titled It's my written testimony, Judge. He's like, well, we're not doing that, right? Yeah, that's what they do, bro.
Dude, they'll say anything. They're a lot like cops on the side of the road. No, I'm telling you, there's a law that you can't look at me funny. You're under arrest. Right.
Judges are people. Listen, judges are people. Judges make mistakes. When the judge lies or misstates the law, he's not necessarily liable just for doing so, because judges are allowed to make mistakes. You just have to correct them on the record and preserve that matter and say, Judge, respectfully, I take exception to your decision or your statement. I believe you're incorrect. I want that stated on the record.
Yeah, we have to really figure out the whole ins and outs when it comes on the federal side for finding the loopholes when it comes to judicial immunity.
Yeah.
The prongs are pretty they're threefold. They are in a trifecta. I do know that. I got a call I have to do up with Robert Ritzman today and probably Joe to figure out what it is on the judicial immunity side that it might be the strongest approach just because from what Robert's been telling me is he's been able to be successful in that realm. So that's going to be a big one for you because when judicial immunity is something you want, come through not having any issues with.
Yep.
And you got to find the loophole to really and match all three prongs to be able to really stand on that. And
So Cam,
at least
do
already
you
what's president. It just sucks. Go ahead.
do you want to work with me on this supplement in front of people for like the next 30 minutes or so and go over it with them?
Well, we've been on 4.5 hours.
Okay.
I was kind of, tailoring this one off at this point just
All
because,
good.
I got commitments. Um, so, but yeah, I do think like your situation's hella deep.
Deep, dog.
Yeah,
Deep.
yours is deep, and people can see just how much you're having to go into it to be able to articulate yourself well and then try to hit on the remedy side. Um, but at the same time, what I really like to kind of showcase with it when it comes to yours is that you ain't never done this before. So now you come from an attorney on the first stop, you jump into this bad boy on the second go round, and now you're this deep into it. But and it's just allowed you to learn so much in relation to what's kind of owed to you that it's going to translate into every aspect of your life, which is going to honestly make you really powerful if there's any wrongdoings in any form or fashion, even if it's the littlest.
Yeah.
Which this is more on the extreme value side of things as far as a life experience is concerned.
Max.
Yeah. So, but yeah, to go to see just where you've come from to where you are now, as far as a pro se litigant, and then having all the challenges being presented to you tells a true story of one that's just like I'm not, because I'm sure there's points where you get like overwhelmed, right?
Sure.
But at the same time, you're like, I ain't gonna let that emotion override, what I find as far as my conviction is concerned, which is very important because some will get tied into that fear and that worry of the unknown, right? And
Yeah.
that just leads them to not, you know,
To give up.
yeah, to give up and succumb. And then when you give up and succumb, it's like, bro, but you got so many other more steps to go. Like,
Yeah.
you're at level 1, bro.
Yeah.
It's like there's a whole pyramid here. Don't you want to get to the top of the pyramid and bask in glory, bro? Like you may be in the darkness right now, but the sun, you get above that shadow line, and now you all the way at the top, shining in glory. You just gotta take the proper steps and go have the conviction. And so that's what's important is there's always a narrow way when it comes down to the faith and true comprehension and conviction of sovereignty. I know as hard as they may make it be, I feel like that in itself is a challenge worth bringing not only to yourself but that you owe to your family. And that way you don't just have everybody laying down to where it's complete that flame is completely non-existent anymore as far as the fight and the comprehension of the people. And it's just elevating each other to get back to that baseline at least, but that just means that the baseline got to come up a little bit. And I feel like, yeah, it's not for those who want to know, at least we can help and it'll trickle on to our families, right?
Yeah.
Rather than being depleted in and of itself to where it's non-existent in families. And it's not to say that we combatant in any way. It's just standing up for true sovereignty and self-governance, which is directly, that's what we live in. And if you're trying to tell us different, then you're really taking away the core principles of my existence and freedom. Which, man, it gets deeper and deeper and deeper. So there's layers to this, but that stronger conviction on the inside just will not allow anyone to give up, and it's clearly being shown through you. And I just really appreciate you and commend you for keeping that going, bro.
Yeah, man.
Amen.
I appreciate I really do appreciate the love and support. I appreciate the guidance of Wisedome. I appreciate, the information and knowledge that I've learned from Wisedome, from you, Cam. I hope that I shared something today that kind of hit a note for some of you guys that are a part of this and anyone that's reviewing online if it gets posted on YouTube or anything like that. Hopefully there's some stuff that you can take away that really kind of shows you that this pro se movement is not easy. But the lessons that you learn, just like Cam said, the man that you become or the woman that you become throughout the process is irreplaceable. It's going to serve you in every realm, not just in law, but it'll serve you throughout the rest of your life. So,
Yeah, you just got so many things going on too. It's like how are you not seeing it as complete as I am? So I know that gets frustrating because
yeah,
of course you're gonna catch frustration when you don't get things that's really owed to you anyways.
yeah,
Um, like I got it going on my side, so it's the same thing. But yeah, I think your persistence is key, bro. It comes down to conviction, and that conviction is very clear within you. And I'm just like, bruh, keep it up, my G. Like, keep it up, my G. Um, because you're just getting stronger and stronger in every form and fashion, and this is only gaining experience for what's to come, right?
yep,
So you're just building muscle. You know, that mental muscle and that mental mass of experience leads on to greater and greater perfection of oneself. And that's what's beautiful to see here is that you're continuously perfecting self. And it just overall feeds out to everybody else, which just says, look at this experience, and then what am I going through, and how can I relate, and then what can I utilize? Like you got to understand, like some people within the Discord in and of themselves that are Operation Wisedome members, they get full access into the Discord, so they're just like checking out what's going on to how it may apply to them, right, in their
yeah,
situation, to see how these courts are treating certain things. And then what we're finding in other states, right? Just in Minnesota recently, we ended up finding that, pleasure vehicles is used as an exemption, and it has a clear description of just taking trips from here to there. But yet, pleasure vehicles is not defined within the act in and of itself, which of course acts give life to statutes. So when we get on certain realms, you got to understand that certain things apply all across the board that can be utilized. And yeah, you've given a lot of golden tickets, I think, in here, especially within California, but just on the process in and of itself, that's going to allow one to say, okay, yeah, maybe what's relating over here in the rules, as far as my sector is concerned, is going to help benefit me. And yeah, that's cool about that. For sure. Experience, bro, to all gives
experience, yeah.
the eligibility to figure out more. And so with those depths, yeah, the principles are here. It's just crazy that you got the tampering and the purging of information in there that really
Yeah.
wasn't being seen but could possibly be seen within the appellate
The,
court.
the federal court did respond that too. So just to kind of clarify, you guys, I learned that lesson. Don't make assumptions of law and legal conclusions, especially in federal court, because they will shut that shit down like they did with me in the response. They said the video evidence that you show does not show that there's tampering or anything. It doesn't show any of those things. It does show that purges were extended and that they were uploaded to cloud files and they could be retained. So they were very quick to show to clarify what the record evidence does show and what it doesn't show. What it does show is that there's a need for factual development. There's questions that need to be answered. There's a cognitive, uh, objective viewpoint that the record produced may not be complete. But all the factual development really needs to come from an evidentiary hearing, and that's where you can build all that stuff. Now, what it looks like when we look at it, it definitely looks like, yeah, y'all for sure did this, that, and the third. And I mean, me just knowing how they've treated me throughout the whole process and how everything's happened and how, man, when I tell you what it's like to go into a hostile environment, guys, every time I stepped room in that fucking courtroom in front of those judges, it felt like the most hostile environment. I mean, when I first took over Pro Save myself, they would,
See, that's where you gotta manifest it different though.
yeah,
Like I feel like for me anyways, what I be doing is I seriously be manifesting like like a charming atmosphere,
yeah,
right? And I guess it changes the whole mentality in the electrical vibration of the mentality in and of itself from
yeah,
more of an adversarial me against you to like, yo, let's really get to talking about these and laughing about it in a sense, right?
yeah,
Because when you get into that way of thinking, they honestly have fun with it too.
yeah, for sure.
And even they start being like, okay, well, if that's the case, then look at that as the way the state will look at it, Mr. Wilson. The
Yeah.
court will start talking to you like that too, because you're joking
If you're
around.
professional, yeah. You
Yeah,
know,
no, for
if
sure.
you speak their language, they'll take you serious and they'll be like, okay, I can work with this guy. Like, he fucking actually knows something. You know what I mean?
Yeah, it'll
But
be a total different response too on
yeah,
like how they're if you're coming in adversarial, well then you're gonna get that back, right?
yeah,
And if you come in with like, listen here, Your Honor. First off, the state did this. Now I'm going and you come in with this charming type. We gonna laugh about it a little bit. And you know what? There's another thing. Just the way your delivery,
yeah,
at least on my side, has always been that like, look, okay, I see homie knows his shit, but the state is seeing it this way, Mr. Wilson. If they're going to come back at me in any form or fashion, it's more of, a light demeanor, right? Because I'm seeing they're saying, okay, well, we I can understand how you can see it that way. But the state, there's at least an explanation on what, and they may take me for a little slow, right? Sometimes I may be a little slow with it, but sometimes I'm just you know faking and facading the slowness there just to get a comprehension and a record of how the court is going to take things and interpret things. Your demeanor is key, bro. Your demeanor is very important too on the relationship that you established with the actual prosecutor in and of itself, because again, they're just acquiescing to what's been brought forth on them. But if you're establishing a relationship with that prosecutor, bro, right off the jump, you can get in and say, look, there were some constitutional violations. I don't think the state's willing to support on this. And y'all go through that. And that's
yeah,
informally. You dig what I'm saying?
yeah,
Because you are your own attorney. So it's always one to say, I'm gonna take the perspective of, instead of being like, I'm gonna get y'all and I'm gonna go after y'all, is how can we work on, establishing or getting through the constitutional violations on the front end? Like,
yeah,
y'all ain't the police department. The police department did this on their own type vibe.
yeah,
And that is so much different too on the
yeah, bro.
yeah, your relationship gotta be good, bro.
Yeah. Hey, that's really valuable. And I wish I'd have heard that from you, Cam, way back when before I first started taking over. You know what I'm saying? But I was in a different mind frame back then. Back then, I was like, I couldn't believe they was prosecuting me, bro. I was like, I know you lied about the blood. Why? What are you guys doing and why? Why are you doing this? Like, there's no way that you would do this. So I was just in disbelief in general of like the whole scenario and how it was developing. I was like, I can't even believe that you would even try to prosecute me for this.
Yo,
Like,
that's kind of the that's I guess that's kind of the gift that I may have, right?
yeah, maybe you
Is
do,
the
bro.
the fact that, I can come to somebody, anybody, and have them truly understand my position as far as the fairness of the whole deal. And while some it's hard for them to be receptive and relate and to take that internal knowing. But I think we as Americans have come to understand that our country is based on true fairness and just leave me the hell alone.
Yeah.
And I think that yes, while it has been somewhat suppressed in certain methods, it's not suppressed in others. And and we can talk about multitude of things that have changed over time that, bro, just recently, you know what I'm saying? Like, just for shits and giggles, we turned on Jerry Springer, right? And bro, nobody's ever seen Jerry Springer for a very long time, bro. But just watching one episode, just one, we didn't binge watch it or nothing. We just looked at, like, what was that, 15 years ago? The differences of the society then and now is just on the mental set changed so much as far as be who you want to be, right? And
And
uh be what you want to be, but we can't be what we want to be over here on this side, which comes with the deeper, which is your faith. And that's just tied into self-governance. So I think that has to be a little bit more prevalent because the administrative rules that are set upon this country, which is not, it's more of the preemptive. We're doing things to protect a possibility that is not actually has happened, is where we got to get back to the mindset, and that is across all administrative uh, 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 infractions or statutes that are not true common law where there is a corpus delicti. That administrative side of things actually has to kind of stop, bro, because it's harming the people more than anything. But that comes from a mindset, right? But at the same time, you got to look at how many things are about to change over the next 10 years as far as a mindset is concerned. And that relates back over to the financial sector of things, right? The financial sector, we started this off before this recording, is about to change so much as far as how we live with the creation again of this AI and the robots and everything being implemented. If you think things are going to be the same in 10 years as far as the financial side, you're crazy. And then what does that do? Right? Does it actually create more violations for us to pay as far as regulations are concerned because of it? So it's kind of weird in relation to just regulations themselves and one's thinking that they're directly across the board, not just with traffic, but with all these civils as well. It's just a restructuring actually of the true freedom that one has. And that comes from a mindset that has to be overall ingrained or understood first on a family level, um, within our own teachings again. But then just make sure that we're keeping it on check from the school systems too, which is cool. It's just ingrained in your own teaching and by showing, and not showing by any kind of force. It's just, bro, that's how you truly live. And that's how I truly live. It's like some people would be like, "Do you really feel true and brave?" It's like, hell yeah, because I really don't have anybody telling me what to do. You know, I got my private obligations between the establishments as far as what I deal with, but beyond that, no one truly interferes with my life other than the police. That's it. There is no other faction out there that has any kind of ill will towards me or obligation that I must abide by. And my whole thing is that I don't commit crimes. So why should there be any, you know,
Right.
you know, so it's kind of like it's a the way of life is just internally. It's just how you deal with what you deal with in life. Now, whether you want to say, "Oh, well, you have to do this," or they say that you have to do that, bro. If I'm required to do anything, it boils back down to my faith as far as not being required to do anything. Because if I was, then that would mean involuntary servitude. So the deeper principles are always there, no matter what case law or stare decisis you pull from, because it's faith based. It's a conviction within, right? And that can never be taken away. And so when you're constantly fighting everything that you're fighting from in the in the very core existence of it, even though I see you fighting on all of the rules that are currently established, I think the underlying agenda still should be there in some form or fashion, whether it's in the conclusions or at the very beginning of the creator endowed rights, especially with corpus delicti and the corporate side of things. Um, and always a notice of special appearance off the jump. There's no doubt. And maybe even through the verification of reservation of rights section as well, because those are always very keen. It's like, bro, y'all are over here, you know, bringing forth a regulatory scheme, which is defined as a scheme in and of itself based on a federal corporation, which thereby makes the state a subsidiary of said corporation. And even that little bit tidbit allows you to understand where we're getting from as far as the Article 1 and the administrative law side to the Article 3, which is the common law. And I feel like you invoked really good things within like the constitutional framework of things. I just feel like the only thing that really got you even hung up was the argumentation. Well, y'all both going back and forth in the way that y'all was doing it. I'm bigger than you're bigger type vibes. Then you go into contempt. Then the motherfuckers even coming through and being like, okay, well we're gonna dismiss this if you sign this, and then the judge being recused and having to move somewhere else. Like, how did that even? What is all this, bro? Um, I'm in the purge. Like, how is that not laid forth in the direct appeals for a complete reversal? Like, what is going on here, right? So, I mean, if you have the extension on the brief, it should be pretty good, bro. The brief, including with whatever he's accepted now, should be good enough to get. What? Are you kidding me? You just don't want to. You just yeah. Your evidence should be very clear. That's all I'm gonna say. And if your evidence is clear, you're gonna be golden, my bro. I wouldn't trip at all. You just gotta be golden on that for real. Um, yeah, your brief. If they have issues there, taking it up higher again from here is just gonna be it's gonna make the issue even broader across the board. But you have to, man, your brief should be banging, bro. If he even keeps out evidence, your brief should be banging. I don't know if you're speaking or not. I can't hear you. Maybe you fell out because of your.
I'm here.
Okay, okay. Yeah, your brief should be banging. Your brief should be banging, bro. That's all I'm saying. Like this one should get turned around. I think there's just saving grace on the lower side, but the higher side should be able to view it really well.
Yeah.
All it takes is a good articulation. The higher judges look at things a lot better, bro. A lot better. Yeah, the higher courts definitely. Yeah, and it's conviction too, bro. It's conviction, bro. The conviction's got to come in at some point. And it can be very small. But you're doing really, really good on the argumentative side as far as case law is concerned, procedure, the documentation. It's very in depth, and it has to be very in depth because of the things that you're bringing forth. You found a lot, and you're bringing forth every angle, and that's very strong. You got to be, you know. Commend you, my boy. Okay, check it. We've been in this thing almost now 5 hours. We're gonna end this one on Saturday's Operation Wisedome. Yeah, apparently I had to remove prospective members and free membership into his channel by the request of Michael. So just Wisedomians have the access at this point in time. And then yeah, bro. Check it. I commend you again. Keep it up. Yeah, we'll keep going on the make sure that the brief is, on point, help you bring forth everything you need to bring forth in that in comparison to what is not being included or was excluded at this point. And yeah, it's going to be interesting to see where the direct appeal goes because of this serious violations. I'm just amazed, bro. You got a big one. It's kind of all over the place. I'm just looking towards the future too, as far as the judicial immunity and how to overcome it. Yeah. Yep. Got to meet all the prongs. Got to meet all the prongs.
Yep.
Thank you guys for sharing and breaking it all down for us. It was really great.
Yeah, it's deep, bro. His is deep, bro. His is deep, bro.
Yeah, I gotta say, Michael, I like your approach, man. I agree with just so much of what you had to say today, and this was just an excellent class overall. This was crazy.
Yeah, he put in a lot. Yeah. For sure.
Remember, my approach did change, especially recently. You know what I'm saying? Because it originally started off, I was a little conflictual. I was kind of like pissy with them. You know what I'm saying? Like, this is malicious prosecution. What are we doing here? You know what I'm saying? And eventually, I learned that you got to be really tactful about how you address things. And then I really, really learned how evidence works. Right? Read those federal rules of evidence. Read those state evidence statutes, because it's important to read that and understand it. Because you got to remember, if it's not in evidence, it's not before the court. It don't matter if it's present to you. It doesn't matter if you understand. Like, look, I'm looking at the evidence right now, Judge. He's not looking at it. He can't see it if you haven't moved it into evidence. So once you learn the little ins and outs and the little what I call the fundamentals of law and procedure, which Cam is really good at, you'll start to realize that, man, you really just got to present the shit the most legally and lawfully effective way, and you got to use judicial notice appropriately. And if you do that, you can present to the court exactly how to make the court move. And once you do it, there's a record, and these judges will act in accordance because they know they're on record, and they know there's a record with the requested judicial notice that's lawful that they have to take. And they know that if they go in opposition of that judicial notice, in opposition of the law, they can be held liable. So these judges, I've learned recently that when you do it the right way, when you do it respectfully, when you do it appropriately, and you remember, for me, I had to slow down on my appellate division filings. If you read them, you'll see them. You'll realize I kind of switched my tone from, oh, there's violations, to, oh, there's a need for factual development. Oh, they tamper with evidence. I switched from that to, oh, there's a need for factual development. There's a need for more evidentiary research and investigation. And I think that hopefully, if you guys continue to follow and you continue to see as I progress, I think I'll start making some leaps and bounds pretty soon. I think we're going to start getting some. I think we're going to start moving really, really quickly. So stay tuned.
Yeah, the appeal is going to be important, bro. Most definitely. All right, my G. I appreciate you. Very, very much, bro. Keep up the fight. We staying up to par on it.
Say something real quick.
Yeah, go ahead.
Can I say something that won't be on YouTube for the record?
Oh, okay. Yeah, let me close it out. All right. This is going to be the ending of Operation Wisedome. Again, this is August the 22nd. Michael Carey is our dude from California fighting his DUI, going at all levels here. You dig what I'm talking about? And I'm just really proud of him. I just wanted to make sure that I let y'all know and just keep up the great fight, bro. You're doing a service here, and you're just empowering yourself as well as everybody else. So keep it up, my G. You're doing great, bro. For real,
This
for
your
real.
first case?
Yeah, this is first case.
That's wild, bro. You're badass.
Yep, he's fucking badass, bro. My nigga. All right, my G. We're stopping the recording on this one. Y'all peace out.
Michael, I appreciate you,
Peace
man.
out, peace out, peace out.
Man, that was the shit.